what we've been talking about this morning is the media review. And we just had a discussion off the record about whether you could maybe spend some time over the lunch hours trying to clarify that. I'll just ask the open-ended question, starting with, is there more than one media review? And if so, can you just please explain that?
This is the media review that the CO was referring to.
When you say this, the one that you were looking at?
Yes.
And we can
this
make
is
that.
in fact what she directed and what was produced by Matt and Lynn.
Okay.
I think there was additional media information that was submitted with the protest as well.
Okay. I think that clarifies it. Some of the committee may have some follow-up questions there, but I appreciate the clarification that when we use the term media review in the testimony, we are referring to that document, which I think the committee can make part of the record. And if any folks want to get more detail on that, we can do that. So in the interest of moving on, I'm going to move on. Before we broke for lunch, we were, I think, just moving into kind of talking about cost, caseload ratio, and some other topics. So I'll start more generally. In DHHS's view, what does it mean to be a responsible bidder with respect to this RFP?
It means a bidder that's able to provide the services, which that comes from Chapter 81, which is the commodity statute. It speaks about responsibility, but the commodity statute was pulled over in part by the procurement manual through the authority under Chapter 73.
So does being a responsible bidder, understanding that the bidder can provide the services, does that have a cost component? Can provide the services for the cost detailed in the RFP, or only that that entity can provide the services?
Yes, it's not explicit in Chapter 81 or in the procurement manual, but if you look at the definitions and what you look at for responsibility, the ability to provide the services, I mean, it arguably is implicit that if when you're looking at the vendor through the bid, to be responsible, they would have to provide the services that they're offering at the cost proffered.
And just, Mr. Patello, the feedback that I got from the morning is that folks are having a hard time hearing you. And I forgot to mention that before we got started. I think the microphone doesn't move, but if you could adjust it maybe a little bit, I can hear you fine, but I do want to make sure, and if any of the committee members needs Mr. Patello to speak up, we'll try, but I sort of forgot that. And the reason I said that there is because at the cost proffered, is that what you said?
In the bid.
Okay. So let's talk about the St. Francis bid. At the time of the award to St. Francis, did you believe that St. Francis was a responsible bidder using the definition you just provided?
Yes, I had no reason not to believe at the time of the award.
And what, generally speaking, was the basis for your belief that St. Francis was indeed a responsible bidder at the time of the award?
By your, you mean me personally?
You personally, we'll start there, and if you can't answer personally, we can talk for DHHS as a whole.
Yeah, I hadn't reviewed, I was not an evaluator. I did not review the bid. So based off of the evaluation that went to CFS and as a result of CFS wanting to make the award after their review of everything, I had no reason to tell them or to think that they were incorrect.
At the time of the award, did you personally, in your role, I think at that time, at the time of the award, you were back to being COO and general counsel,
yes,
and no longer interim CEO. But at the time of that award, did you have an understanding of the cost differential between the Promise Ship bid and the St. Francis bid?
I would have seen the cost proposals, I believe, yes.
And so in addition to the cost proposals, is it fair that you would have also seen the rest of the RFP responses? So for instance, the responses as it related to caseload ratios?
I did not.
You did not?
I saw the final scoring.
You only saw the final scoring. At any time before today, so I'm going to go all the way back for several years here, have you had occasion to review St. Francis's RFP response, that original RFP response?
Not in its entirety. If there's issues or concerns with the contract or whatever, and it can't be handled with the contract attorney, then those will come up to me. But no, I have not read either bid proposal from start to finish.
When you say either, you mean either Promise Ships or St. Francis?
Yes.
Okay. Do you have an understanding, however, of what Nebraska law requires regarding caseloads for case managers in the child welfare system?
Yes.
What is that understanding, just so we're talking?
By statute, it requires a 17-1 ratio.
Maximum
less.
17 to 1.
Yes.
Prior to the St. Francis RFP response, had you ever heard the term dyad model?
No.
Since the St. Francis RFP response, have you come to understand what dyad model means?
Yes, in that it's more than one worker assigned to a child or a family. I think a caseworker plus a support worker.
As of 2019, I'll just use the contract date. Prior to July 3rd, 2019, were you aware of any use by the state of the dyad model as it related to the provision of child welfare services?
No.
That was not a concept. Is it fair to say that was just not a concept that the state, utilized?
Not that I'm aware of.
When is the first time you can recall hearing the term dyad model?
When it was either from the director or from the deputies and they were discussing it.
In conjunction with St. Francis's proposal?
Yes.
And with respect to St. Francis's proposal and the dyad model, was there a view within DHHS in that discussion about whether the dyad model would be in compliance with the 17-1 statutory requirement?
I don't know if necessarily the model in itself would not comply. You would still need to have the sufficient number of case managers to comply with the ratio. As far as I understand the model, it just speaks to the number of people assigned to an individual case. So as long as the case manager number is sufficient, then I would imagine it would comply.
So let me maybe try to restate your concept back to you. So the mere use of a dyad model would not necessarily render a bid non-compliant with Nebraska statutes. Is that fair?
Correct.
It is really the caseload ratio that is proposed, regardless of a dyad model or some other model, that may or may not render that RFP response compliant. Is that also fair?
Yes.
Within DHHS, we were talking, I asked you before if the dyad model was discussed, but within DHHS, was the caseload ratio proposed by St. Francis more generally discussed prior to the contract being signed, but after the intent to award?
I don't know. I became aware of the issue when the protest was filed. But I would suspect that all those bids were discussed within the program.
I'll try to characterize what I think you mean by the issue, and you tell me if I'm correct. St. Francis's original bid proposal included a caseload ratio of 25-1, right?
Yes.
And when you say the issue, is that the issue you're talking
Yes.
about? And so 25-1 on its face would not comply.
It would not.
How was that non-compliance of the 25-1 caseload ratio communicated to St. Francis?
When the protest was filed, that was raised in the protest. Clearly, if they were going to stand on a proposal that had a 25-1 ratio for case managers to children, I think it is if they're out of home, and I think it's different if they're in home. But if they weren't going to abide by the statutory requirements, then the protest would, in essence, we wouldn't be able to award. I mean, you would probably uphold the protest and dismiss their bid. So the procurement folks reached out because, again, there was this ambiguity, right? They're saying that we're going to meet all statutory requirements and all regulatory requirements, and that was explicit in the T's and C's, and it was addressed in the Q&A period. But then there's this language in the technical evaluation or proposal, which was evaluated and scored, that's inconsistent with that. You can't do both, right? You can't have a 25-1 ratio and say you're going to apply with a statutory requirement that's at most 17-1. They're mutually exclusive. So the procurement then reached out and asked if they would, and I can't remember, but it was an email to Tom when we were trying to finalize the contract going into the contract negotiations, basically asking if you were going to meet this ratio. There was a response from Tom Blythe, who was the COO, that appeared from his response that he was interpreting that email to say that we're asking you to add bodies to it. And if you're going to ask us to add bodies, then we're going to have to increase the cost. And at that point, I said, no, you have to meet the ratio at the cost bid. And then we just went into the negotiations so that can be resolved. So it's rather than emailing or trying to do red lines back and forth, I just needed to know, are you going to meet this ratio at your cost? If the answer is no, then the state can't go forward with your bid.
Thank you, and thank you also for setting out that timeline, because I think it's going to make these questions make a lot more sense, hopefully, for the rest of the committee members. That communication you just described from Tom Blythe at St. Francis, just so the record's clear, that's who you were referring to?
Yes.
Okay, and so Mr. Blythe responded back and said, if you want us to meet this ratio, this is my summary, it will cost an additional $15 million plus, correct? I think it was 15.1 maybe, but was that his response? He emailed back and said.
He emailed his response back, and I can't remember exactly what he said, but the way I interpreted his response is that if you're asking us to add more bodies, then it's going to cost us more money.
Okay.
And that's not what the state was asking. The state is asking, are you going to comply? Yes or no?
And I think there has been some characterization of the process that happened next as a clarification meeting. Are you familiar with that?
Yeah, I mean, that would be your contract negotiations, which there's very few contracts that don't. Bidders will take exceptions to terms and conditions, almost always, and those things have to be negotiated. If there are other, deviations or proposals that the state's considering, and that all that has to be resolved prior to the contract to be executed. And in this particular RFP was designed so that you would have to have a final negotiation meeting with whoever the bidder was, because there were terms and conditions that were specifically left open to final negotiations. I think they had to do with auditing forms or so much and so forth. So it was designed to do that.
Okay, so I'm going to use the term clarification meeting, but only for consistency's sake. Please don't read into that terminology. It's just consistent with some of the other briefings and testimony that the committee's had. So that clarification meeting, which I believe happened on June 26, 2019, I would just like to ask for some detail around that. So that's what I'm referring to. And if you take exception to the characterization, I'll note that, but it's really for ease of reference for
That's
my
fine.
sake. Okay. So with respect to that meeting, who decided to have that meeting within DHHS?
We were already preparing to have that meeting. And due to the issues with the ratio and the protest, I wanted to have it sooner rather than later so that we can resolve whether or not we can go forward with this bid or move on to the other vendor.
Okay, so the information provided by the department, I think it's a pretty lengthy agenda with an appendix.
Yes.
It's got a sort of 9-page agenda. I want to understand for the committee's work, who attended the meeting. So just to be clear, I'm going to go through the invite list, and let me start by asking, did you attend the meeting?
I did.
Okay. Did Tom Blythe attend the meeting?
Yes.
Did Diane Carver from St. Francis attend the meeting?
There were at least 2 other people from St. Francis there, and I don't recall their names. One of them was a female. One of them was another gentleman. He was the CFO. I remember that.
Okay.
Diane may have been the female, and I can't remember what her role was.
Okay. Did Peter Kroll, Kroll, attend the meeting?
Yes, I believe so. He would have been from DAS.
DAS. And then how about Greg Walklin?
Yes.
And then there were some optional attendees at the meeting. Nancy Storant?
Yes.
She was there?
She's a buyer from DAS, and I believe she was there as well.
And are you also looking at the same invite list, Mr. Botello?
No, I'm
Okay.
looking at my notes. You want me to go through the notes I have?
No, that's fine. It's just a few more names. How about Keith Rowland? Was he there?
Yes, he would have been a HHS buyer.
And how about Dale Shakowski? I believe he was DAS counsel.
He was, and I don't remember if he was there or not.
And Matthew Wallen
Yes.
and Wes Nespor,
Yes.
NESPOR. Okay. And then Lori Harder
Yes.
and Ross Manhart.
Yes.
Anybody else that I didn't list that you can recall being at the June 26, 2019 meeting?
Did you listen at Walton?
I did not, although, so she was the organizer, so I probably should have started there. I assumed she attended.
I believe so, yes.
And so anybody else other than Annette?
No, I don't think so.
I think you've answered this already, but in your view, is a clarification meeting like the meeting that occurred on June 26, 2019, contemplated in the procurement manual?
Yes.
Just describe why you think that's the case.
It's explicitly in the procurement manual. I can't remember the section, 6.18 maybe? Contract finalization. So what I would recall in the clarification meeting, because we're trying to clarify whether or not their intent was to comply with the ratio or not, but that's the contract finalization meeting.
So looking at 6.18, and if you need to refer to it, it is in the, you might have your own copy, but it's also in that black binder next to you. The procurement manual, and you're correct, it is 6.18 with the contract finalization section. Going into the meeting in June of 2019, what did you understand the department's options were at that point in the process? And when I say options, I'll refer you back to Ms. Smith's testimony from January, where she sort of set forth we could do one of 3 things. I mentioned a fourth thing this morning. I want to know what your understanding at the time of the meeting was with respect to what DHS could do next.
So when you're trying to finalize a contract with the vendor, you're either going to come to an agreement, in which case you move forward with the contract. If you can't come to an agreement, you can, depending on why you can't, you can reject all bids and start over again. You can, typically what you would do is you would move on to the next vendor. You would reach out to whoever the next vendor was, the number two, ask if they would continue to honor their bid. And if they say yes, then you go forward in negotiations with that vendor. If that's not an option, in the Eastern service area, it's a critical service and you have to have continuity of service, right? So you can't not have this service. So if you can't reach a negotiation with the number one vendor, you can't get it to number two, you're going to have to find a way to provide that service. It would fall under, you can either go into a new contract in an emergency if there wasn't, but you would have to have a vendor to have that emergency contract with, right? Or the state would have to do it themselves. It's not like a service contract that would be optional to the state or one that simply you can just wait to do. You have to have a continuity of service in the Eastern service area. You can't not have case management services in the Eastern service area.
Understood. Going into the June 26, 2019 meeting, do you believe that all of those options were legitimately on the table at that point?
Yes.
Was there a discussion at that point prior to the meeting about potentially still, awarding the contract to Promise Ship?
Well, I mean, the options would have been discussed, right? If you can't finalize a contract with this vendor, you have an incumbent who is also on a bid. So, I guess that would be your natural tendency. If it doesn't work with one, you go to two. Assuming that they're willing to, and they submitted a bid, there'd be no reason why they would not.
Was, I'm using some kind of loose terminology, but I think we're on the same page. Was it also on the table that the state could take back the ESA if the contract was not able to be finalized with St. Francis?
That was an option, but that's not necessary. Yes, obviously, this is different than other contracts as well, in that the state does provide case management services, everywhere else in the state. So it's not a type of service that we don't have the capacity to do. We could do that. It would take time, obviously, to build the staffing, and the other requirement is to take that over. But yeah, that was a possibility. You're either going to award it to a vendor or you're going to do it yourself, but someone has to do it.
What happened at the June 26, 2019 meeting? And that's a really broad question. I'm going to give you some leeway to just describe it. In the interest of time, I want you to be thorough. But in particular, I think the committee is very interested in learning what items were discussed and what agreement was reached, and how did the state come out of that meeting with the determination that St. Francis was indeed going to be able to provide these services for the cost bid? I think those are the big questions about that meeting. And so I'll just let you kind of respond to that very compound but thorough question.
So if you look at the agenda, number one on the agenda was the case management ratio. And in fact, if you look at the other numbers on there, it says if necessary, because if we didn't get an agreement on the case management ratio, there's no point going forward, right? You're either going to do it, or you either can do it, or you're going to do it, or you're not. And if they weren't able to meet the case management ratio, at that point, the negotiations would have stopped. the bid would have been rejected and we would have moved on. So that was the first question. Okay, are you going to meet the 17-to-1 case management ratio? Is that your intent? You agreed to do so in the terms and conditions. You have this language in here that's inconsistent with your agreement to meet that statutory requirement. Are you going to do it? They said yes. Then we asked how, and they began to describe that even though they have individuals that are identified in the bid as case managers, and then they had individuals identified in the bid that were kinship workers, but were actually case managers, but only for kinship placements. And so they went through a list of people that were in their bid that were in fact providing case management services, but they weren't necessarily identified in their bid as case managers. So they spent some time discussing all of that. That was considered by the agency, the director that was there and his deputy at the time. They took that information and that was their demonstration of how they would do it. That in essence, they were saying, we have the case managers in our bid. They're just called different things. That was explained to the department. The department accepted that explanation, at least on its face at that time. Later, everything was sent over in paper. It was reviewed, and the department made a final decision.
Yeah, I think that a lot of questions have been asked about that change with respect to, well, we've got the staff built in, but we are calling them other things. And so if there's anything else you could share, Mr. Botello, in terms of the discussions between the state, or I guess the attendees, so that was DAS and DHHS and St. Francis, with respect to those changes, because let me just give a little more background. What I've seen is in the original RFP, we've got this 25-to-1 ratio and, a number of case managers. And then after the clarification meeting, there sort of appears to be this category of 64, therapist / case manager role. Was that discussed during the meeting about, just like this title change, I guess, for lack of a better term?
Yeah, I think what they did was they went through their, whatever they were calling these, their classifications of individuals. And they identified them as providing case management services. And that was explained to the department. So yeah, I think if I recall, those positions were all explained to us.
With that, with the additional information provided after the clarification meeting in June of 2019, was it the department's belief that St. Francis had not added any additional staff, but instead had just reallocated, I guess, by title? I'm just trying to drill down a little bit more there.
Yeah, our understanding was they had the existing staff to meet the requirements of the RFP. I don't believe there was an impression that they were adding people. I believe the assertion that was made is that they were already, that they had them there.
In the department's view of that additional information that was provided post June 26, 2019, these therapists / case managers, was there any discussion about the qualifications of those individuals and whether those 64 people that were allocated in that column actually could be case managers?
Yeah, there's statutory requirements for case managers. So any position they would use for a case manager would have to meet those requirements.
Okay, so the department was satisfied with the materials provided post June 26, 2019, that St. Francis had qualified case managers that could meet the statutory caseload ratio.
That they would provide. I mean, at the time they weren't in existence, but that they were saying that they would provide it, that they had the bodies, that they could meet the ratio.
Did you press them on the cost of that during that meeting? The $15 million request sort of led into this. So I think the logical question for folks, sitting here is, did they really just say, no, we're fine, we've got the people, they're qualified, and just kidding about the $15 million? We don't actually need more money? Did that come up during that meeting?
Yeah, that's where we talked about, we're not asking you to add bodies. We're not asking you to add additional people. What we're asking is, can you comply with this requirement with your bid as proposed? And that's where they went through the staffing and said that they could. And we made it clear that you couldn't, you can't raise the price now. You're either standing on your bid or you're not.
So this, in our information, this staffing plan with the caseload ratios becomes, I think it's B. There was A and then there was B, that's addendum B. And, my review of that submission, and this is just my review, appears to be that these kinship workers were sort of just reclassified as case managers, or maybe the sort of changing of the qualifications happened so that they could be reallocated as case managers. Was that discussed during the June meeting?
The kinship workers were definitely raised, because I remember them describing them explicitly. And if they were used, and if they were going to be used as case managers, they would have to meet the requirements of it, which I think is a bachelor's degree, I think, for a case manager.
So when it was discussed, the kinship workers, what did you understand these kinship workers were? Did you understand, when you heard the description from St. Francis, did you understand that those folks would qualify as case managers?
The way I understood that what they were is that they were in fact providing case management services to kinship placements.
Oh, okay, but that they would qualify as case managers. Sorry, I don't mean to ask the same question again.
They would have to, right? If they're going to be counted as a case manager, they would have to qualify and meet all the other qualifications of a case manager.
With respect to this sort of, what was provided relating to the staffing plan before the June meeting and what was provided after, was it DHHS's view that that second staffing plan was a change to St. Francis's RFP response, that constituted a change? If they're, I'm trying to remember how they had it laid out in their original bid, but what we interpreted that, or what we were interpreting that to be, is that they were agreeing to comply with the RFP requirements. And they were telling us how they were going to comply with the RFP requirements. And it may have changed their bid, but it changed it in a way that ensured compliance with what the state was trying to procure. put you on the spot for a moment, Mr. Botello, with respect to the June 2019 meeting and give you an opportunity to respond maybe to some of the, I guess, characterizations of that meeting. Some have indicated to me that they believe that DHHS was going to great lengths to ensure that this contract was awarded to St. Francis, and that DHHS was sort of going above and beyond with allowing this staffing plan change, allowing case ratio change. I'll let you respond to it, but the first question is really, do you agree that DHHS was indeed going to great lengths to ensure this contract would be signed with St. Francis?
No, I mean, to me, contract negotiations occur almost with every bid, right? We're trying to ensure whether or not they would comply with the contract. So it didn't seem extraordinary to me.
Okay, so again, sort of sitting in my shoes here, it doesn't look logical that an entity could go from a 25-to-1 caseload ratio on, and then with the same number of people somehow manage to achieve a 17-to-1 ratio. And I think we just want to understand why that seemed logical to DHHS, that would be possible.
So when they went through their staffing, it didn't appear, at least it didn't appear to me, that they were adding personnel. If you're not adding personnel, then the personnel that are in the bid should be built into the cost. And what they kept saying is that we have the people here to do this, that they're in there, that we anticipated, or that through these other jobs that they were doing, that it was sufficient. And that was described how they would do that in detail to CFS, and it made sense to the program.
So thank you for that response. I will confess I haven't just added up the number of bodies in each of those proposals, but I've done some rough math. I haven't, from a CPA standpoint, added up with the certification, but it does appear to me that there are more numbers of people in the later staffing plan that was ultimately posted, to the website, than what was in the original proposal. Do you have an understanding of whether that is true? There were just more human beings in that staffing plan to do the same work that they had proposed to do?
I don't recall there being new people. I recall them repurposing them, but it could be true.
Okay, so, and maybe that's the answer to my question of whether in conjunction with that June meeting or at any time in the contract finalization, whether you or anyone in DHHS just ran the numbers, right? Was there an effort to determine, are they adding staff without adding dollars?
I did not.
Are you aware that occurred within DHHS? Do you have any understanding that someone was doing that?
Adding?
Are they adding staff but not adding dollars?
Not that I recall.
Gonna try to move us to wrap to stay on schedule here. I know folks here have lots more questions, but in your view, was the proposed, that initial 25-to-1 caseload ratio a minor error or a minor defect?
I don't think it was in error. You meaning that it was inadvertent by St. Francis?
Let me maybe ask a different question. The 25-to-1 caseload ratio, if it had not been changed to comply with the statute, can we agree that would have been a major defect which would have resulted in St. Francis not ultimately signing this contract? I mean, we wouldn't have offered the contract.
That's correct.
I'm gonna ask just some really top level questions and then turn it over to Chairman Arch, but you were here for Ms. Smith's testimony this morning and perhaps even familiar with her January 2021 testimony, where she said, you know, nobody in DHHS knew that St. Francis had underbid the contract. So in everything that you have done, both to prepare for today and since January of 2021, do you believe it is true that no one in DHHS knew that St. Francis underbid the contract?
Yes, if you're asking if we believe that they were misrepresenting their ability to perform this contract, then I don't think anyone at that time believed that. They affirmatively said they have the bodies, that their cost was proportionate to what we needed to get done, and that they would meet the requirements and they could do it at the cost. They said it directly to us. And at that time, I don't think there was anyone who had any information that would refute that. So we took them at their word, if that's what you're asking.
Mr. Botello, you're very experienced in state procurement and in particular within DHHS and DAS. And I'm not. I haven't done the jobs that you've done. But as just a person coming to this and looking at the facts before me, it does seem very almost preposterous to think that a bidder could do the same work for 40% less. Did that enter your mind at any point in 2019? Just how can St. Francis possibly do this contract for 40% less?
So that question was asked, and the impression of CFS was that the cost with St. Francis would have been comparable to what their own cost would be. So it's
CFS's own cost?
Yes.
Okay. Please finish. I didn't mean to interrupt you, but so what analysis was done with respect to? Well, I'm going to go back. I think we talked earlier. The Stevens Group report indicated that Promise Ship's cost was within $100 a kid, right, of the state's cost. So those things don't really compute for me. Then if CFS had determined that it could provide the services for 40% less and that somehow made sense for St. Francis's bid, that doesn't add up to the finding that Promise Ship was only $100 more. Are you tracking that?
Yeah,
I don't understand how those things can both be true. Can you help me?
I don't know what the Stevens Group report based their information on, so I can't speak to that or how they quantified that. What I know is what the program was expressing at the time, which would have been the CFS.
That's helpful. I think at this point, I don't have any more questions for the witness, so I'll turn it over to Chairman Arch for any questions he may have.
Thank you. Yes, I have two questions, and I want to go back to something that you said earlier, almost at the beginning of your testimony, where you talked about the relationship with Promise Ship, and I think that I wrote it down. The structure is difficult to manage. That's a difficult relationship of that lead agency or the case manager, private agency. And I guess I'd like your opinion on this, and this is just an opinion, but you have been around and you've seen privatization. Is there an inherent conflict when the case manager also provides services? And maybe I can.
I understand what you're saying, Senator. So when you have a case management entity
Yes.
who is then providing services to
Yes.
itself,
Yes.
I would say there would be almost no incentive to manage that cost, right? And that's part of the structure that it's one of the reasons why it's difficult to assess cost or manage cost, right? You have a vendor, let's call that a vendor, that's entering into contracts for services. But those payments for those services aren't paid by the vendor, right? Those are reimbursed by the state. So the state is reimbursing for all these, regardless of who's providing those services, the state is reimbursing that cost. The vendor then enters into these agreements at whatever it negotiates that cost. There's not a lot of incentive for that vendor to try to drive that cost down. In fact, it may disincent that in its entirety.
I agree. And I think that even further than that, the conflict of what the case manager is tasked with versus what a provider is tasked with is quite different. The provider wants to provide services. I mean, that's what they do. Case manager has a different task. And I think about the 35% cap on direct provision of services that's in statute. And why that would be in statute, and I say this conflict of I'm a provider and I'm the case manager could be part of that. Any comments on that?
I'm not sure why that was there. It would prevent the vendor from providing services themselves. There had to be a reason for the legislature. I'm not sure.
Okay. Second question, and this is just for clarification. I got a little confused when we started talking about deviation, RFP, a deviation from the RFP versus what I would term non-responsive, which I'm assuming would be defined as a material defect. And so the glossary of terms in the RFP for the deviation, it talks about any deviations from the RFP in sections 2 through 6 must be clearly defined by the bidder in its proposal, and if accepted by the state, will become part of the subaward. Any specifically defined deviations must not be in conflict with the basic nature of the RFP requirements or applicable state or federal laws or statutes. So there's provision for that, and earlier it says the state reserves the right to waive any deviations or errors that are not material. But when you kind of to Marnie's question about when you see some of the, I'm not sure what you would call them, but the case ratio, the 25-to-1, the 50-50 self-performance, staffing plan changes, those types of things. Now and I guess this is now with your legal hat on, what would you characterize those as? Deviations? Would you characterize those as deviations, or I'm trying to understand how the state saw this RFP that did not comply?
So they did two things. They affirmatively said we're going to comply with these requirements. And then in their technical solution, they proposed a solution that was inconsistent with that. The technical solution is evaluated by this group of evaluators, right? And the way this RFP was set up, you can structure RFPs in many different ways. You can structure it such that you have a series of what I call go, no goes, right? Will you do this? And they go through that and say yes, no, yes, no. And depending on the yeses and nos, where they are, you stop right there. This RFP didn't have that type of structure. It asked for how are you going to solve this problem, right? Which the bidders then put in there what their solution was. Those solutions were evaluated. The evaluators took that information and scored it. They scored the bid as is, assuming that it was an alternative. Those scores then come up and you compare that with the T's and C's. The evaluators don't see the terms and conditions. Those aren't evaluated. You can have a vendor that takes exception to every term and condition. That's not considered in the award decision. You then have to go and negotiate every single one of those. So when this thing comes up, it goes to the program, the division, the bidding agency, which was Department of Health and Human Services, CFS. They're reviewing these bids and the scores. They then make a recommendation to DAS. I don't know what the consideration was at that time to that ratio. I do know that they bound themselves to meet that ratio.
So did I understand you correctly to say that the evaluators then did not evaluate against compliance? That was the way the RFP was written.
No RFP is, Senator. The terms and conditions are submitted by the vendor, but that's not part of the evaluation process. Those are left to, those come to me in legal to then review the exceptions, and then we negotiate those exceptions. And the cost doesn't go to the evaluators, at least not the ones that are evaluating the technical solution. They don't see that. They get I don't know what the components are. There's corporate overview, there's the technical solution, which is the biggest part of it, and there's other components. So they're evaluating that. Typically, it's the same group that evaluates all those sections, but you could have different ones as well. And I can't remember what we did for this one. Then the cost on the Nebraska model is really an objective evaluation, right? You have the cost, they get scored. You decide how much points you're going to give to the cost proposal. The low cost gets the most points, and then there's a formula, that's a DAS formula, that then divvies out points from that total based on where you are with the high, and you just come up with a point score. That's added in to the other components, and that's your high, and that's how you determine your final score. But the T's and C's, the terms and conditions, those are we going to agree to these statutory requirements? That's not evaluated. That's left to us to negotiate. Okay,
that's helpful. I mean, I would use the term quality. The quality is not part of the evaluator's process. It is, nor is necessarily statutory compliance. It's a different evaluation. So even when it comes to the cost evaluators were not evaluating on reasonableness of cost. It was, are they costing it appropriately? I use that term loosely, but
depending on how you structure your cost proposal, you can ask for different things in your cost proposal. I'm not sure how this cost proposal was structured, but really the scoring of cost is based on the number, right? It's an extremely objective evaluation, high to low, or low to high.
Okay. And it's a formula. I mean, it adds up, and that's the number. Now, when those evaluations are complete, is that when it comes to you for determination of compliance with statute, or when does that get raised to your attention?
It goes to whatever would be the director, whoever's making that decision as to whether or not to accept the scores or not. It goes to them. It doesn't come to me for the T's and C's until the decision has been made. There is no consideration to how many exceptions vendors take to the state's terms and conditions in the award process. that's left to us to negotiate. Sometimes the negotiations take months to get through those, depending on the vendor and the amount of exceptions they take. Sometimes you can't get to resolution on that because there are certain components, those T's and C's, the state can't waive, like choice of law, right? The state of Nebraska, sovereign state of Nebraska isn't going to agree to be held to the law of New York, right? We're not going to give, we just can't do that. So you'll negotiate these T's and C's after all the intent and all that has been done. That's when you get to that component. And you either come to an agreement or you don't. If you don't come to an agreement, you move on to the next vendor. If there is an next vendor, or depending on how long it is, they may not even be willing to accept their bid.
Okay. Is there a point anywhere along this process of award where there is an actual decision made, yes, that is a responsive bid?
Yes, when the evaluations are done, once your evaluation is done, the scoring is done, and those go to the decision makers, right? That's when that decision should be made. If there's an issue with it, then it gets resolved there, and then the state makes this. The state has discretion in that to an extent. I mean, case law in Nebraska gives procuring officials fairly broad discretion, but that's when that calculation would be made, right? The evaluations are done, everything's scored, the cost is in. We haven't even addressed T's and C's because, quite frankly, Senator, I don't think anyone considers the terms and conditions until after they decide they want to award this contract. Then we have to go and try to negotiate these things. But that sort of responsive or reasonableness analysis would have to occur in that time when the evaluation's done and the state makes the decisions whether or not we want to award.
So prior to the award, prior to the intent to award, after the evaluation, and you said the decision maker, so not, I assume not you, but rather the department director or whomever is in that chain of authority to make that call?
Yeah, it's almost, I mean, legal doesn't, our role is one to provide support and counsel, and that I don't have any, like, legal doesn't have any contracts. If legal was bidding a contract as a division, then we would be making that decision. We're part of that and we're a consultant, but we don't award the contract.
Is that an actual formal decision? I hereby declare this to be responsive.
Well, no, I mean, those types of, the process doesn't have a second process, right? When you look at the Nebraska procurement process, you're relying on the procurement process. You're relying on the evaluation of these bids, and there's sort of reliance on that the process itself is reasonable, right? You've gone through the bid process, you scored it. Then it goes up to the decision makers, right? They're looking at the scoring result. They're relying on the scores and the evaluators. And in that time period, although it's not expressed anywhere in the process, so to speak, although statute 73, if you look at section 73 of the statute, it lays out DAS. And then it speaks to if it's an agency bid contract, and it in there expressly directs directors when they're making a decision, kind of what things they would need to consider. But that consideration, that calculation would occur post-evaluation prior to intent to award.
Okay. Well, given that there was an intent to award, whether it was part of the process, it was determined somewhere along the line that this RFP response was responsive, that the bidder was responsive, or the intent. I mean, you say it's ahead of that, the intent to award would not have been issued.
Right, it should not have been, right?
Okay. All right, I'll pause there. Questions, Senator Clemens?
Thank you, Mr. Chairman. Thank you, Mr. Rutello. The legal counsel mentioned a $15 million adjustment. Was the contract increased by $15 million?
No, which contract are we talking about and when?
With St. Francis?
The original award?
uh,
No, an original award, the contract, the cost was not increased.
All right. So at the execution of the contract,
They agreed that they can comply with the terms and conditions of the contract at the cost they bid.
okay, it was in the legal counsel's comments, it talked about a $15 million amount. Do you know where that comes from?
Yeah, that comes from an email from when the original communication went from either DAS or DHHS procurement saying that, and I can't remember what was in the original email, but in essence, they were trying to determine whether or not they would comply with the ratio. And there was a response back from St. Francis saying that, if you're going to ask us to add bodies, that we're going to have to add money. If you're telling us we need to bring additional people to the table, then we need to add money. And I responded back saying, you can't add money. You have to meet the contract as it is, or we're not going to award to you, right? You can't increase your cost at the time of award. You either can do it or you can't.
So that it was, just executed without an adjustment. The original bid then was signed,
Yes.
the contract. Thank you.
Marty, I believe you have another question.
While we're talking about cost, Mr. Botello, I'm sorry if I've created some confusion, especially for Senator Clements here. The cost, or I guess the price that was going to be paid to St. Francis did ultimately increase by approximately $18 million in conjunction with that move up date on the case transfer to October. Are you familiar with that?
Yes, when we moved up the start date to transition the youth earlier. Yeah,
Yes.
so then you would have been paying for services at an earlier date.
So while the overall, it's fair to say that while the overall contract increased by $18 million, that was in conjunction with getting services for that increased cost that were not originally contemplated in the RFP.
Correct.
Okay.
The start date was moved up, so their contract performance date was moved up.
I just wanted to clarify because I think those increases in numbers, and I wanted to make sure that that was clear, that there was indeed a cost increase, but that was correlative to a provision of services. Thank you, sir.
Okay, Senator Colterman.
Thank you, Senator Arch. Mr. Botel, thank you for being here today. I'm going to switch gears on you a little bit here. My goal being on this committee has been, and I don't think there's any secrets, to upgrade the procurement process. And in fact, I brought a couple of bills to that regard. And even prior to me, Senator Shoemaker brought some bills. At the time in 2019, I brought LB 21, and the sole purpose of that bill is to put in place an appeals process so that if this happens again in the future, there's an appeals process that's outlined in statute that one could follow, and it makes it so that we don't move forward until the proper appeals have taken place. On LB 21 in 2019, I had a whole bunch of testifiers in support, and there was only one testifier in opposition. And at the time, I believe you were legal counsel for DAS. Would that be correct?
What year was that, Senator?
2019.
No, I would have been in HHS.
Okay, well, you testified in opposition to that bill at that point in time. Then I brought another bill in LB 61 in 2021, and Jason Jackson was the only one that testified in opposition. And the bill really didn't change, it just set the level from 5 million up to 10 million. I guess where I'm going with all this is, as we have evaluated the process in the state of Nebraska and the process that we go through with procurement, we've looked at a lot of different models that a state could adopt. There's the American Bar Association model out there, which we have a little bit of that in ours, and we've used some of that language. But there's also 49 other states. Do you really feel, after seeing this and YPRO and other items that have come about, that our procurement process is really adequate? Or do you think there's too much? And the second question is there too much discretion being placed on the process?
So the procurement process itself is different than what your appeal process would be in essence an APA type of hearing, right? That would occur after the procurement process. So that gives, it's a methodology of release, but all that post-procurement, right? A protest is already post-procurement by time, and the state has a protest process. It's just not under the APA. If you're asking me, is the current procurement process really what it should be? I would say that it's old, right? We're operating on a process itself that in essence is already 20-something years old, and hasn't really been changed much. Not the protest process, but the procurement process, right? The needs of the state have evolved significantly since these statutes were written in 2000, right? Which means the types of services and contracts have changed dramatically. So I mean, if you think about it, you have all these pegs, and those pegs would be your services. They're all different shapes and sizes, but you have only one hole to try to put those pegs in. You're moving all these procurements through the same process. The ESA contract, right, is this hybrid of a staff augmentation and kind of mixed with a sub-award. It doesn't fit well into a process that's really designed to procure commercial services, right? Commercial type contracts, IT contracts, software as a service, which isn't a service, it's a lease of intellectual property. But that type of procurement doesn't fit well into the service process as well as the commodity process. So I think when you look at the state's procurement process, you have to understand that, and it's a paper process. It's all paper as opposed to any type of e-procurement. So, you know, when you end up with a contract that's 4 binders, you know, consists of 4 binders that are each 3 inches, 4 inches thick. That's because there's no way to really synthesize the RFP and the end result into what would look like a commercial contract, because it's all paper based. So I would not tell you that the state's procurement process is all that it can be. And I would not say that the state procurement process doesn't need to be modernized. What I will tell you is that the procurement process is different than the protest process.
Okay, and I appreciate that, and I appreciate your willingness to maybe consider that. Then let's take a look at the appeals process. Under our current appeals process, there's really there's no legal avenue to approach that from, as I understand it, in the process. You have a process in place. Would you explain how that works? Because the concern that I'm hearing from the general public, the people that are putting together these multi-million-dollar proposals, is that if we don't get the bid, there's really not a very good appeals process that we can utilize to appeal our bid. And let's take a look at in this case, $218 million contract at the end of the day. Well, it costs a lot of money to put together a $218 million contract. And if in fact, it's just going to go back to the internal process that DAS has established, and you're going to have one person over here that says, yeah, I think they got a fair deal. There's no process that says they can appeal it right. And what we're saying is, on any contract of 10 million or 5 million or more, there ought to be a process that somebody can utilize. Otherwise, what's going to happen is, we're going to have these bidders that are not going to want to come and bid because they're thinking they're getting homered from the get-go. What's a done deal to start with? And so tell me about how the current appeals process works, and why shouldn't we at least try to fix that, which LB 21 and LB 61 tried to do.
So the current appeal process would be the DAS protest process. If DAS is bidding it, and if it's an agency bidding it, then they would handle the protest, but it should be conducted in basically the same manner as the DAS would. There's two stages, or it can be combined into one stage at the option of the protesting party. First stage is to the materiel administrator, who would be the one that would execute the contract, saying there's a problem, this is the problem, we want you to look at this. That's then reviewed. If they're not happy with the review of the materiel administrator, they can then appeal to the DAS director and have an in-person meeting with the DAS director if they want. The appeal to the material administrator is done via letter, by paper. The DAS administrator then can make an independent decision of the material administrator as to uphold the protest or not.
But there's no really outside party looking at this and saying, an unbiased party looking at this and saying, no, you're not getting a fair deal.
The state's procurement system is not within the APA, which is the Administrative Procedures Act, which is what you're referring to, which would go to a hearing officer. A hearing officer would make a decision, and then you would appeal de novo to the district court from a hearing officer's decision, if you wanted to go further.
So has the thought ever entered your mind that we could lose bidders in the future if we don't correct this? I'm asking for your opinion on
that. I suppose that's possible, Senator. I don't know how the protest process is figured in or considered by vendors. I guess I can't. Could it? Yeah, I suppose. When you're doing business with the state or a public entity, you're constrained by that process. So I imagine all of that is factored in to whatever their decision making is.
And then I asked this morning of Director Smith, when a proposal is put together, and she indicated, like in this particular case, DAS was involved with that and HHS was involved with that. They came together and they evaluated, both sides evaluated, but the final decision was made by DAS at the recommendation of HHS. I get all that. I asked her if anybody else was involved in that. I think I used the governor's office. What I was really talking about was the budget director. Does the budget, on contracts of this nature, would a budget director get involved with the $250 million contract? And the reason I'm asking that is we've got another, pretty soon we're going to have an RFP going out for Heritage Health, the renewal of Heritage Health, which is going to be multi-million dollars again. And I would think an item of that magnitude ought to have more than just HHS, DAS, possibly the budget director or the governor's office ought to be involved with that. Correct? Is that a wrong assumption?
Those contracts and those services should already be calculated into the agency's budget. The budget director doesn't sign off on I guess if an agency has a question of cost, I am aware of instances where we've gone out to bid. By we, I don't mean HHS, I mean the state, because this would have been when I would be in at DAS, where they've gone out for bid for services. All the bids came in above what their budget could sustain, and they had to reject those bids and in essence refine their RFP, ask for less to get it within their budget. So the budget determinations should be made prior to going out to procurement. You have a kind of an idea of like for the MCOs, they're there, right? So we know that that's part of Medicaid's budget. So that would be calculated in through their financial officer, and budgets are sent out to the governor's office and submitted by the governor to the legislature. And so you have this budget that's approved already. But as far as an independent sign off by the governor's budget office on any particular RFP, they don't do that, Senator. That's not that I'm aware of.
I'm just asking because I wanted to understand the process a little better.
Yeah, it's up to the bidding agency to understand its budget and what it can sustain, to the best of my knowledge.
The other thing I was told when we were doing our investigation of all this was that there's probably 100 contracts over $10 million a year. And they were concerned that this process of appeal would slow the whole thing down. But can you comment on that? Are there that many? You worked in DAS. Are there that many?
There are a lot. Where you would
contract?
be concerned would be those contracts that require a continuity of service. Not every contract requires a continuity of service, but some do, and they tend to be the bigger ones. Eastern Service Area is one that requires a continuity of service. The Medicaid contract, the MCO contracts require a continuity of service. The current protest process doesn't stop the state from moving forward, and I think you were talking about that earlier. It doesn't pause it. The state still can move forward, whatever it's doing, negotiations, execution, whatever. If the protest process is going to pause that, so if however, if there is a new protest process designed, appeal process, if it pauses the actual award and moving forward the contract, your concern would be for those contracts that require a continuity, right? So you would have to either move up your bidding process so that you're bidding much earlier, accounting for some measure of time for maybe a prolonged protest process to ensure that you can hopefully get to the end of that prior to the expiration of the existing contract. You can extend contracts in the state law for 1/2 of the original term, but you can only do it once. So if you're already on an extension, you can't extend your incumbent. You could enter into an emergency contract with an incumbent for a period of time to get through this, but that would be the calculation that you would need to consider with the protest process that pauses the new award.
So let's go back to where.
Senator Coulterman, I'm concerned we're going to run out of time this
I
afternoon.
just have one more.
Okay, all right.
So let's go back to the current process that we had in place here with, we awarded this contract July 1st, if I am correct. And prior to that, there was a protest made in June of that year, 2019, by Promise Ship. Would that have put you on record of knowing that, maybe we need to have a stay on this so that they would have to keep their contract in place until that process was heard, or that grievance was heard? Are you following my logic?
No, sir, I'm sorry.
So as an example, they filed their complaint on June 14th. They protested with DAS.
Who's
Promise
that?
Ship did.
Okay,
And
this is the most recent protest.
yeah, and then they awarded the contract on July 3rd of that same year, knowing that there was a conflict, that there was in place. Why would they have awarded that? I guess that's where I was going with that.
Who's they? DAS?
DAS.
There would be nothing stopping them to award that. That is what I would tell you. So I know there was a timeline that there was a lot of concern because the transition. That current contract with Promise Ship had already been extended, if I recall correctly, so we couldn't add time.
So you
to it.
couldn't extend it again.
No, we couldn't. So, I mean, the CFS had this timeline, this sort of Gantt chart of all these things that needed to get done for the purpose of transition. So they were very concerned about having time to do that. In regards to DAS, the protest itself doesn't pause the award. So there's nothing requiring them.
But you could have signed an emergency contract had you needed to.
We could have, yes.
Thank you. Thank you, Senator Arch.
You bet. Other questions? Senator Kavanaugh?
Thank you. Thank you, Mr. Patello, for being here. I wanted to go back to Senator Clement's question and council's sort of follow-up. The 18 million that was given, I just did some quick math based on the cost proposal of St. Francis Ministries, and their monthly cost for that 3 months would have been 9,400,000. So is there an additional reason that they were given 18 million and not the 9,400,000?
I don't know, Senator.
Okay.
I can go back and try to figure out how that cost was calculated.
I think that would probably be helpful for everyone. Thank you. Okay, and now this is a little bit longer. I'm kind of trying to put through here how we got to where we are on the evaluation part. So the evaluators only use the information provided to conduct their evaluation for scoring, correct?
The evaluators evaluate the bids and
Yes.
only the information, yes, that's
Yes,
correct.
okay. And then the cost is awarded using a formula. The
Yes.
cost points are,
Yes,
yes?
yes,
Okay.
that's correct.
The Stevens Group provided a cost analysis, and you had stated that CFS, Child Family Services, determined that this cost was reasonable, disregarding the Stevens Group's analysis of what was a reasonable cost for these services.
When you,
So the Stevens Group had the cost at around $100, the same as DHHS providing it themselves. And our legal counsel asked about why was it then decided to ignore that? And you said that CFS said that this was a reasonable expense proposal.
by this expense, do you mean the cost proposal by St. Francis?
Yes,
Yes, they did.
okay. And did you have conversations with, at that time, Director Wallen about that?
No, not, I mean, did I question it? Did I challenge it? No, I did not.
Okay, so the decision was made to award with no, basically an audit of the ability of the vendor to deliver on what they said in the bid. And my understanding is that from what you have stated here today, let me know if I'm misunderstanding, that their ability to deliver on the bid would be determined during the, as you said, T&C, terms and contract?
No, the terms and conditions of the contract, there are a list of basically what Mr. Archer is calling compliance, and that's probably a good way to put it. It lists out all the laws and regulations and other conditions that aren't subject to bid that the state's saying you have to do.
Okay.
And then the vendor, when they submit their bid, they either check yes or no by all of those components.
Okay, so the vetting process of the claims of deliverables is taken at face value from what the vendor says they can do?
Yes, it is.
Okay, so my background is in nonprofit development, so I'm familiar with nonprofit budgets, and I'm looking at the St. Francis budget, and the first year of the initial contract is 50% less than the rest of their years. And that to me is an immediate red flag that I would have asked, why, how can you provide new services, start this whole big transition year one at 50% less of what you're going to provide it in the continue? That should be the most expensive year?
I think the first year wasn't a full year. So and when the original bid came out, the first year for St. Francis would not have been a full year. So their cost was just for whatever the portion the original bid would have asked them to provide.
But Promise Ship's cost was bid at a full year. But I actually, it's by month, so their monthly costs are less. Their monthly costs are 1.3 million in the first year per month,
Mhm.
and their monthly costs in the following years are 3.1 million. That's what I'm talking about, not the full, I mean, actually the full year, then administrative costs, et cetera, are 50% less as well. But I'm stating that this would have been a red flag, and I'm not hearing any checks and balances as to how we would have not done this. And I guess I want to our legal counsel's point, I don't understand how there was never a conversation with anyone within DHHS or DAS to say, this doesn't look correct.
So the first year in monthly costs, I think there was ramp up time built into that contract. So that they weren't necessarily providing services. I can't remember. I'll have to go back and look at how that was structured. So I don't really know. In regards to the cost itself, that was considered by CFS. They've looked at that and they made a determination. The mechanics of the contract and how the costing was required in that first year, I can find out and I can get that for you.
Okay, but just to getting back to my point, I'm sorry, that kind of took us away from my point, is there was no point in this entire process where anyone stopped and actually determined, not taking it on face value, but actually determined if they could fulfill the contract.
So that was all part of the consideration in the award. So even after the bids, the evaluations came in and the normal process was done and it goes up to the director and his team, that happens at that point.
And is there documentation of how that was determined? Because I apologize if there is, I have not seen documentation that says they will have this X number of employees that are case managers paid X amount of dollars. That you can do simple math. I mean, if you pay them $33,000 and they get, $15,000 in benefits and multiply that by 110, you can figure out if their budget is real.
No, if you're talking about did the state attempt to reverse engineer the cost? No, we did not. I'm not aware of it, and I would be surprised if we did. In fact, I don't know if the state has ever attempted to reverse engineer, to my best of my knowledge. It's just not part of the process that we've ever done. So I would suspect not. So.
Okay, I have a lot more questions, but I'll stop for now.
Okay, all right. Senator McKinney.
Thank you. How do I put this? Okay, so I don't know if you have kids or not, but if you do, you've been taking your kids to a daycare for X amount of years, and it comes a time where you're starting to search for other daycares. And just hypothetically, I'm just using a hypothetical, you spend $1,000 a month on daycare. But then you go to this other daycare provider that says, I could do the same care for $600, $400 less. Would you ask questions about how is that possible? Or would you just say, wow, that's great?
I don't know, Senator. Perhaps, yes.
Because I asked this because it seems like throughout this whole process, nobody ever took the time to step back and say, how is it possible for their proposal to be 40% less than promised ship? And actually take a step back and ask them and ask yourselves, how is this possible? How is this going to get pulled off without negatively affecting the kids? And I just think that is something that, is disheartening that, we have a departments and organizations that, in my opinion, weigh the value of spending less over the value of making sure our kids were properly taken care of. Thank you.
Other questions? I want to remind the senators we have 2 other testifiers coming. Other questions? Okay, all right.
I do think we committed to each witness to the opportunity to make any statements in closing. If there's anything in addition that you haven't had a chance to share, Mr. Vitello, this would be your opportunity to do it. I know we've covered a lot of ground. I'll encourage you to think hard about whether there is anything you haven't shared that you need the committee to know or would like the committee to know. But I do want to give you that opportunity.
I don't have anything else.
Thank you.
All right, with that, thank you very much. Yeah, thank you very much for your testimony today, Ms. Botel. Appreciate you coming.
Thank you, sir.
Our next testifier is not here at this time, so we're just going to pause for 5 minutes and we'll resume then in 5 minutes. Thank you. Okay, we will resume our hearing. And Mr. Jackson, I believe that you are next up.
May I sit?
Please, yes, please. And thank you for coming today. And we're swearing in our testifiers today. So if you would raise your right hand. Do you swear or affirm that the testimony you're about to give to this committee is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may begin.
Right, good afternoon, Mr. Jackson.
Likewise.
I'll maybe save us some time here. Although you weren't present this morning, did you have an opportunity to listen to at least the opening remarks this morning from the chairman and kind of what our process is going to be
I did.
today? Okay, thank you. So I'll say it again. My name is Marnie Jensen. I am
Pleasure to meet you.
Yes, you too. Special counsel to the LR 29 committee. I'll give you the same warning I gave everyone. We're trying to stay fairly structured and stay on task. That desire is increasing as we get further and further into the afternoon. So with your testimony, I'll ask you to stay as succinct as possible, but we do want thorough answers to the questions. So if I interrupt you or if one of the senators interrupts you, it's merely to sort of keep things going, but we do want you to have the opportunity to say what you'd like to say today.
Thank you.
Mr. Jackson, we did give particularly some of the witnesses the opportunity to make some opening remarks. We asked you to keep that to 5 to 10 minutes, although it's not required. Do you have any opening remarks you'd like to make this afternoon?
I do, and I expect I'll come in far under 10 minutes.
Okay,
So,
fantastic. Yeah, go ahead.
So thank you for the opportunity. Chairman Arch, thank you for the opportunity to be here. If my memory serves, this is actually my first time in front of the HHS committee. I'm generally in front of government and military. And so to that end, several of you I haven't had the opportunity to meet before. So Senator McKinney, pleasure to meet you, sir. Senator Day, pleasure to meet you. And Senator Kavanaugh, pleasure to meet you as well. So thank you for affording me the opportunity to be here. My name is Jason Jackson, Jason, Jackson. I'm the director of the Department of Administrative Services. Generally speaking, administrative services is responsible for the back office business operations of state government. By state statute, we're organized with a number of divisions. So among those would be State Personnel Division, which basically administers all our HR processes, Accounting Division, which manages our accounting operations, Building Division handles all our facility management across the state, Risk Management handles our insurance portfolio, Transportation Services manages our vehicle fleet, and of course, Material Division administers our state procurement of goods and services on behalf of our customer agencies. In addition to those agencies, we have a HR shared services team that supports 13 boards and commissions with their end-to-end HR needs, as well as our Center of Operational Excellence, which deploys to our various agencies to support process improvement efforts throughout the state. All in, we have about 310 teammates across our agency. I understand this committee's work is particularly focused on Material Division. Material Division itself is organized into 3 components. So it has a mail operations division, it has a surplus property division, and then it has state purchasing bureau. We just kind of conversationally often refer to state purchasing bureau as state procurement or just procurement or material division. So I may lapse into just conversational language, and if at any point clarity is required, I'd be happy to try to offer that. To give you a sense of kind of the breadth and scope of material division generally, we administer about 700 contracts across the state with a total value of about $6 billion. In any given year, we handle about 200 contracts on behalf of our customer agencies. To perform that work, we have a team of 10 buyers and 2 supervisors, generally organized into teams of kind of services and goods. So that kind of gives you an idea of just kind of how we're organized around the work. From a process standpoint, I think you heard several of the testifiers this morning, and I wasn't able to catch all of it, but some of the testifiers this morning spoke in some detail about the process, but just kind of at a high level. State law generally vests DAS and Material Division specifically with responsibility for goods purchases in almost every instance. And then it affords agencies discretion with whether or not to do their own services contract or leverage DAS to perform those contracts on their behalf. in all cases, in a services-related contract, and I think Danette may have touched upon this morning, when there's a $50,000 threshold for an RFP. So it's at that anticipated dollar amount that we would expect there to be a competitive bid process. And in every instance, whether or not a agency is partnering with DAS to actually conduct the process in partnership with them, or whether they're administering it themselves, we would have an expectation that they're complying with the DAS process. To give you a sense, and Chairman Arch, I understood your question and several of the questions of the committee to be less specific to this particular procurement and more just kind of big picture, what does this mean for the total health of the process? Of those 200 contracts we handle in any given year, we see that 2 to 3% of those are protested. So about 97% of the time, a contract doesn't result in a protest. Among those that are protested, DAS generally sustains the protest. In other words, decides on the side of the protester about a quarter of the time. So it's not a perfunctory process. It's a process that we take seriously and attempt to actually execute with a high degree of fairness and objectivity. That concludes my prepared remarks. And with that, I'm happy to respond to any questions you may have.
Thank you.
Thank you, Mr. Jackson. My questions are going to start with some background questions. I know you've just given some background, but I'll maybe go into a little bit more detail. When did you join the Nebraska Department of Administrative Services, which I will call DAS?
I believe it was December of 2018.
18?
2018.
18,
Yes.
sorry. And did you join did you join DAS as director?
I did.
And what was your prior experience, in particular with Nebraska's procurement process, prior to joining DAS as director?
I had no previous experience with Nebraska's procurement process.
Did you have prior experience more generally with procurement, just not Nebraska's process?
I mean, throughout my career, I've been in various operational and HR roles, both in the private sector and in the military, and had occasion to use various procurement processes in those organizations.
Thank you. Generally speaking, you talked about approximately 200 contracts a year that DAS is involved with from a procurement standpoint. This is personal to you as director. Of those 200 or so, how involved are you? Like, what percentage of those are you personally involved in, or overseeing, or just asking questions about? Just any involvement?
Yeah. So generally at the point of procurement, no involvement. Okay. And that's very deliberate, again, because our protest process stipulates that I am a second level of appeal if a protest were to arise. And so to that end, in an attempt to maintain objectivity, and really just so if a protest were to come to my desk, it would be a matter of first impression. I don't involve myself in any specific procurements.
Is that would your answer be the same regardless of the amount related to the RFP? So I'll try to ask it a different way. The procurement process that we're going to talk about this afternoon is a very significant, just in terms of not just the import of it, but dealing with Nebraska's vulnerable children, but also the dollars attached. Do you get involved when those things are present, that there's the importance of it or the dollars attached? Do you personally get involved in those procurement processes?
No, there's no threshold of risk that would say, hey, I as a director need to involve myself in this procurement. If anything, I think the analysis would cut the other way, that the more momentous the contract, the more important it was, the more scrutiny it would likely to be applied, all the more so that we need to adhere to our process, which calls for me to not be involved and rather maintain objectivity. So in my experience in the 2.5 years that I've been a director, I don't have any recollection of involving myself in any contracts.
Okay.
Until the point of protest.
Thank you. Well, and so let's talk about this particular RFP process, this particular procurement process that resulted in St. Francis and that ultimate contract, but especially the intent to award, who at DAS had the primary responsibility and authority for that particular RFP process?
That would be the Material Division Administrator.
Okay, and who was that in 2019? Do you know?
It was Doug Carlson.
And I understand Mr. Carlson is no longer at DAS.
Correct.
Do you know where he is today? Is he working somewhere else?
Yeah, I think he took an opportunity at the university.
Okay, thank you. Just a little bit more background. Mr. Jackson, what steps did you take to prepare for your testimony this afternoon?
Admittedly, not as much as I would have liked. We've been in the middle of negotiations with NAPE and FOP on increasing wages for our 24/7 facilities. And I hope some of you have seen the news that welcome development just today that we were able to finalize an agreement with NAPE that would provide for raises of between 15 and 30% for our workers at our 24/7 facilities. So a very happy development there that's been monopolizing a lot of my time this week. So I hope the committee will extend me a little bit of charity because my preparation hasn't been as rigorous as I would have liked. I did do a kind of a cursory review of the promise shift protests. I also did a brief survey of what I understand to be the governing law and our procurement manual.
Thank you. That's helpful. And if at any point in the questioning, either by me or one of the senators, you think it would be beneficial to do a little bit more work and prepare something, and we're happy to accept something after this hearing as well.
That's gracious of you. Thank you.
If that's beneficial. Okay. Did you or anyone at DAS share or discuss the questions and topics provided in advance with any representatives from St. Francis?
Not to my knowledge.
Now, Mr. Jackson, your office received requests for information from the committee through council. Are you aware of that?
I am.
And what did your office do to identify, review, and then provide documents satisfying those requests?
I directed my team to fully comply. I understand that over 1,000 records were presented to you at about an investment of about 60 hours of staff time. So it's my expectation that that has been fully complied with. Specifically, we would have looked through our documentation retention records specific to this procurement, applied the date range that was provided by the committee, as well as the search terms that the committee provided that they expressed interest in understanding if there were any records that were on point for those.
Thank you. Are you aware of any instances where potentially responsive documents had been destroyed prior to receiving the committee's requests?
I have no awareness of any destruction of any responsive documents.
Thank you. What role did your DAS material division play in developing the RFP itself that ultimately resulted in the award to St. Francis?
I think the previous testifier testified to that DHHS, our customer agency, would have developed the RFP. That's generally consistent with our expectations when an agency engages us for a services contract. They're the subject matter experts in terms of what they need from the procurement. It wouldn't be atypical for our material division to provide an agency with some sort of template or kind of a, just a general outline of an RFP. Just to give them kind of a guidepost or a jumping off point for their own technical development. But the preponderance of the RFP development work would have occurred at the agency level.
At DHHS in this instance?
Correct.
And what was your understanding in 2019 about which agency bore the ultimate responsibility for the fairness and legality of that RFP process?
Yeah, if the question is to the process itself, that's the responsibility of DAS.
What's the basis for that understanding?
I think state law dictates that DAS is generally vested with responsibility for the processes around state procurement generally. And that's our expectation.
So there's been a lot of conversation and testimony this morning, and even prior to today, trying to understand who ultimately made the decision to award to make the intent to award, which ultimately led to the contract with St. Francis. The testimony this morning from Ms. Smith was that ultimately that is DAS's decision based on the recommendation that DHHS provided. Do you agree with that testimony?
I would say it's a shared responsibility. I
A
would
shared
say,
responsibility, I'm sorry, I didn't hear you.
yeah.
A shared, okay.
A shared responsibility, that's right. I would say that when we partner with a customer agency, both parties have a veto, basically. DAS is responsible for the process, and that's where our subject matter expertise lies. The agency is our customer, that's kind of my language, our customer agency in terms of executing the procurement on their behalf, is responsible for the actual technical evaluation of if they're getting what they're buying. And so to that end, it's a shared responsibility.
So I'll ask it as I've asked everyone, where does the buck stop with the decision to award the bid to St. Francis? Does it stop with DAS or DHHS?
Yeah, it's a bit of a curious question. I heard you pose it to earlier question. Frankly, I think it's atypical. I mean, it's antithetical to how we think about decision making, right? The question seems to presume a level of territorialness about decision making that isn't how we conduct our business. We regard it as a team sport, and we all succeed or fail together. And I think as policymakers, that's the way you would hope it would be. I don't think you would want a process where DAS procurement professionals could overrule the judgments of subject matter experts in the agency about what they're buying and what they're paying for, and ultimately the program they're responsible for delivering. So I analogize it to like a law getting passed. Who's responsible for a law getting passed? Well, the legislature votes on it and the governor signs it. I mean, it's a shared responsibility. It doesn't happen without both. And that's the way we comport our business.
So I'm not sure if you heard Mr. Patello's testimony, but as I understood it, and this won't be verbatim, but as I understood it, in his experience, there have been instances where DAS does indeed question the subject matter experts and says, this is the recommendation. We are not taking your recommendation. Are you aware of those instances as director?
I can't speak to any of Mr. Patello's experiences.
So, have you had any experiences as director where DAS has indeed overruled the recommendation of the bidding agency?
Well, I would answer the question this way. So I said 25% of protests get sustained, right? So when a protest, and generally you could do the numbers of 6 to 7 protests a year out of about 200 contracts come to DAS for a review. Okay, if those contracts initially, or the evaluators at the agency would have selected somebody other than who protested, and in 25% of the time, we look at the losing bidder who's bringing the protest and say, hey, there's some merit to your protest here. Now, the reason there's some nuance to the response to your question is that doesn't necessarily mean we're overruling them, right? It might just mean that there's a defect in the process, in which case there's a number of remedies that are available to us to either, support whatever the agency's aspirations are, but still protect the integrity of the process. So I mean, that might be an indicator, if that's where you're going with your questioning, that might be an indicator, but I'm not aware of personally any instance in which state procurement has gone back to an agency and said, no, you're wrong. Our judgment is better than yours with respect to what your program is and what you need. And as a consequence, you need to subordinate your judgment about your program and your needs to that of us as procurement professionals.
So I think I understand your testimony, and let me try to summarize, and you tell me if I've done that correctly. Prior to the intent to award, you are, in that period, you are not aware of any DAS involvement to change the recommendation that the bidding agency has made to DAS. But after the intent to award, in the event of a protest, that has happened in approximately 25% of the protest times. So essentially you do, I think I'm trying to clarify, substituting DAS's judgment for subject matter experts doesn't happen prior to the intent to award. But there may be instances, and there are in fact instances, where protests are sustained, which could be considered to be either a material defect or some other reason for the protest, not necessarily that you're substituting DAS's judgment. Is that fair?
I'm sorry, counsel, if your attempt was to clarify, I'm confused. I would just have my previous response stand.
That's fine, and I think we can move on. I think your testimony is fairly clear, but I'm trying to get, it is actually important for the St. Francis process here to understand, because let me just check your knowledge here. You understand that between bidder 1, which was St. Francis, and bidder 2, which was Promise Ship, there was a 40% cost differential in those RFP responses. Do you have that understanding?
I've become aware of that. Yes.
Okay. So I guess I'm trying to get at, in what instance, if ever, would DAS step in and say, 40% is a huge cost differential. Are the subject matter experts doing what the subject matter experts are supposed to be doing? Is there ever that instance where DAS would do that, or would you simply just wait until the protest process plays out?
Yeah. So I'm going to attempt to respond to your question. There seems to be and just from the testimony I observed this morning, this sense that cost is the predominant factor here, right? So let me take a step back and just say, what happens at award, or rather evaluation. So the customer agency, in this instance, DHHS, decides the totality of the criteria that it wishes to see evaluated, and it decides what weight to give each of those criteria. So in this instance, and forgive me, I'm being a little conversational, so I hope you'll just take this as directional. I believe cost was about 25% of the evaluation. So that would have been a criteria that DHHS would have decided, and which that would have been the criteria that DHHS would have decided, and a weight of the total evaluation that DHHS would have decided. So this cost evaluation component is inherent in the evaluation portion. Okay, so that's at the agency level. That's an expectation of the subject matter experts at the agency for the evaluation of cost. And so you're posing this, I won't characterize it as hypothetical because you're asking actual facts, but in any instance, speaking generally, based on my expectations as the director about how material division would conduct itself, we would have deference to the subject matter experts in that field about what they thought was the appropriate cost. I think some previous testifiers spoke at some length about the lengths that they went to just validate their presumption that the cost was reasonable. But in any case, because the cost is a component of the evaluation of the bid, and the customer agency is deciding what that criteria is, what weight to get it, and who the evaluators are, that's the responsibility of the agency to determine. And we wouldn't substitute our own judgment for their judgment.
And you wouldn't substitute DAS's judgment for the agency judgment with respect to those percentages and those weights either, is that fair? So DHHS in this instance said 25%, and that's the weight.
I'm not personally aware of any circumstance in which we would have dictated a different weighting scale other than what the agency would have offered up for themselves.
Do you have any understanding of whether DAS advised DHHS regarding whether to award the RFP to St. Francis?
I'm not aware of any discussions or conversations or a recommendation originating from DAS to DHHS about which bidder to select.
In fact, it's fair to say it went the other way. DHHS was recommending to DAS who ought to get the award.
I think the record substantiates that.
So Mr. Jackson, you said, and I don't mean to mischaracterize your testimony, but I do want to understand maybe that you aren't sure with respect to this particular procurement process, whether cost was the predominant factor. Is that, I don't want to mischaracterize, but do you have an understanding of whether cost was the predominant factor in this award or not?
Well, I think the committee should have records that substantiate that it wasn't the predominant factor. So all I have at my disposal is the same records that you have at your disposal. And I believe that the rating scale awarded cost 25% of the total points available. So I wouldn't substitute my own testimony for the record that you have at your fingertips. But if in fact it was 25%, I don't think it would be fair to characterize cost as the predominant factor.
Okay, understanding that, I think you were mostly referring to math there, so that does make sense. Do you have an understanding of the comparison between Promise Ship's bid and St. Francis's bid in terms of who scored higher on which categories? Do you have a general understanding? I'm not going to quiz you on it, but a general understanding of how Promise Ship's bid shaped up next to St. Francis's in the varying categories, cost being one of those?
I mean, if you'll content yourself with a conversational answer, I have an understanding that cost was one of the factors, about 25%, that the balance of the criteria got into the actual ability of the vendor to perform the bid, the corporate overview, the technical ability of them to actually to do the work, basically the substance of what it is they're going to be purporting to do, and that there was that generally St. Francis Ministries scored below Promise Ship in those categories, but close enough that the cost disparity shifted the overall objective assessment into St. Francis Ministries' favor.
Okay.
That's my conversational understanding.
No, that's helpful, because I think as a committee and certainly as special counsel to the committee, one of the big questions for us is just kind of getting down to the granular information, because I will represent to you that in every single category except cost, Promise Ship outscored St. Francis. So I think that's a factual statement that most of us around the table know. And so I think there's just a disconnect, and if you can't connect it for us, that's fine, but I would ask you to try that. If one bidder outscores the other on 75% of the categories and cost is weighted at 25%, and that is the only category, does DAS have any responsibility in that instance to say, hold the phone, subject matter experts, we need, speaking of conversational, but we need to look at this. This doesn't really make sense here. Do you think DAS bears any responsibility in a situation like the one we have here?
So your follow-up question was, do we bear any responsibility?
Do you think that DAS should have any responsibility, or you could say any involvement? You don't even have to take the word responsibility, but when that is what the picture is that is presented to DAS on that recommendation, is there, I'll use Senator Kavanaugh's statement from earlier, should there be some checks and balances when it comes back to DAS on the recommendation when the situation is as I just described?
So as what I understand your question to be is, if on the general technical execution grounds one vendor prevails, but they score below on cost, should DAS overrule the agency and award the bid to the more expensive provider? I don't presume that that's true. And I don't know what information we would rely on to overrule the agency in that instance, but for information that they would be better positioned to understand if it was relevant or not. So I caught one of the earlier testifiers who said they looked at the cost and thought it was comparable to the way their services were done internally. I don't know if that's true or not, but that would be consistent with my expectation of the type of evaluation that would have occurred at the agency level, because they have the subject matter expertise in the field. They know what the service costs generally. They know what they've paid historically. They know where the market is going with respect to those services. They know the other partners that are out there. And what's more is it's their budget. To suggest that DAS with no familiarity with any of those factors should go in and overrule, no, that wouldn't be my position.
Thank you for that. Who decided to deny the promise ship protest?
I believe the Material Division Administrator decided to deny it at step 1.
Who decided to deny promise ship a protest meeting?
I saw that question, and I'm not aware that anybody denied promise ship a protest meeting.
Do you have an understanding that promise ship requested a meeting relating to its protest?
Yeah, so as I understand, what occurred was the protest was decided at the step 1 level. Promise ship initiated an appeal to the DAS director, as our procurement process calls for. Before that appeal could be considered, promise ship initiated litigation, as is general practice throughout state government. And I think in a manner that protects both parties. Once you've entered into litigation, now you're in an adversarial posture with respect to whom you're litigating against. And in this instance, they were suing me in my official capacity as DAS director. And so just as a general practice, you wouldn't engage in kind of ex parte communications with somebody that you're in an adversarial litigation with that's already commenced. And so when they decided to basically forego the administrative remedy that was still in front of them in terms of appealing to me and initiate litigation, I think communicated to them that we were just going to pause the protest meeting until such time as the litigation could resolve itself. So there was no denial of a meeting. It just contemplated that, hey, to protect both parties, we don't want to have these communications ongoing while a litigation is pending. And since you've decided to avail yourself of the litigation remedy rather than the administrative remedy, we'll pick this up after the litigation concludes.
Just from kind of digging into the timeline a little bit with respect to your last answer. So, and I understand you don't have the timeline in front of you, but I do. So on 7/1, Mr. Carlson advised promise ship that DAS would need an additional 10 days to complete its initial review of the protest. Are you aware that that letter had gone out saying we need an additional 10 days?
I am now.
Okay, and I think my date's right, so I'll represent that it is. 2 days later, DAS upheld the award, and the 5-year contract with St. Francis was finalized and executed that same day. So just 2 days prior, Mr. Carlson indicated, that the protest process needed an additional 10 days, but then the contract was signed 2 days later. So I think that time frame, and Senator Coulterman's not here anymore, but I'm certain he would want me to clarify this based on his prior questions with other witnesses. Why was that time frame compressed into 2 days when the promise ship protest was still pending?
I'm not sure I understand the question.
So, will you agree with me that once a contract is signed, is the protest process over?
No,
Okay, so tell me why not?
because we can still adjudicate the protest. And generally speaking, the contracts we enter into provide for termination for convenience for the state. So the state still has remedies available to us even after it's initiated a contract. It can avail itself of if the protest process were to proceed in parallel with actually effectuating a contract. And if we were to decide to uphold a protest, we would still have remedies at our disposal to address that.
Is upholding an award the same thing as denying a protest?
I can't say that I know.
Is the decision to deny a protest solely within the discretion of DAS?
Yes.
What factors guide DAS in that decision to deny a protest?
Again, I'll speak generally and conversationally if that's permissible. I would expect basically to do our due diligence with respect to what is the protestant, if that's the right word, what is it that they're alleging within their protest? Was the process generally fair? Was the RFP addressed? Was the was the evaluation conducted properly? And just generally, whatever it is that the protest is alleging it contributed to unfairness. Here I would just generally refer to, okay, what guides us in adjudicating these decisions? I believe it's 73501, which is kind of the state's services contracts, which lays out legislative intent with respect to what is the legislature trying to achieve with its statutory regime around services contracts specifically. And that statute specifically says, maybe more conversational than say, but I believe the factors that it lists are generally fairness, objectivity, transparency, and merit or performance. And so we would use that as kind of our North Star when we're adjudicating any type of protest, or for that matter, when we're advising an agency about how to conduct a procurement, is making sure that we're aligned with legislative intent around that.
When you are considering a protest, whether you personally or folks in your department, do you consider whether the bidder to whom the award was given, so not the protester, but the bidder to whom the award was given, do you consider whether that bidder was a responsive bidder, whether that bid was responsive or not?
I would expect that responsiveness would be considered throughout the process, at the point of evaluation and at the point of protest consideration, particularly if the protester raised an allegation that the bid itself was non-responsive.
Okay. And I'm going to ask some questions about reasonableness, which I know if you heard Mr. Vitello, and actually I should ask if you heard his definition or his, I think, explanation for reasonableness. He said that he thought reasonable meant that it was rational, fair, in accordance with the normal course, and sensible. Do you agree with Mr. Vitello's characterization of reasonableness?
I think that's one possible definition of reasonableness. That's not generally the definition of reasonableness we apply in state procurements.
What do you apply in DAS?
Yeah, so the general rule is a bid more than a reasonably prudent person would have expected to pay under the circumstances? And so a reasonableness assessment, at least as DAS takes it, is actually an assessment for a higher threshold. There's generally no provision for an assessment of is a bid too low. What we're interested in when we do a reasonableness assessment is basically is the taxpayer being swindled? Is this bid too high such that somebody is being taken advantage of?
So here we're dealing with our state's, some may say most vulnerable individuals, our children who are in care and in all of our care. And so in an instance where we are talking about child welfare, do you believe that the RFP process, and in particular the protest process, needed to look at the reasonableness of the cost, even the reasonableness if it's too low for the services provided? Do you think that that was an important consideration in the protest process?
Well, so I saw Danette's testimony this morning. I don't think anybody would represent that Danette is inauthentic or insincere in the level of prioritization that she provides in terms of caring for children. So, when I can't substitute my judgment for that of the agency about what their assessment of reasonable was, or what its impact would have been on the total evaluation criteria that they arrived at. I appreciate the committee because I haven't heard any second guessing of anybody's motives. But I believe the state was acting for pure motives here. What I can speak to is what I understand where my subject expertise lies, to whatever degree there is subject matter expertise, is what does procurement law require? And procurement law generally, again, looks to that definition that I gave you. I think that assessment of reasonableness is interwoven throughout the evaluation period, and particularly the cost component. I think Mr. Botello spoke a little bit about what goes into that cost assessment. I can speak in a little bit more detail. But basically, as he said, it's a formulaic analysis where the agency decides how much weight to give cost. And that's appropriate. Is cost their primary factor? Because, and I'm speaking generally about any procurement, right? Because I understand that's what this committee is interested in. I know you have a focus on St. Francis, but I also understand that you're considering reforms to the procurement process generally. But it would be my expectation that the agency is deciding what importance is cost relative to the criticality of the services that they're delivering. I think a 25% assessment, in is almost any instance is reasonably defensible. So they're deciding what weight to give cost. And then generally what happens, just the math, is whatever weight they're giving it, the low bidder gets 100% of those points. And then the next bidder gets a percentage of those points based on their percentage of their proximity to the highest bidder. So that's how we arrive, again, getting back to legislative intent with 73-501 and just transparency and objectivity around cost. It's not a subjective assessment. It's a math problem. But reasonableness is interwoven in that, at least the definition that I provided here. Because if we're doing an assessment and ultimately the low bidder is prevailing, we would say that would satisfy a reasonableness assessment that the taxpayer isn't being swindled for an exorbitantly high bid over and above what a reasonably prudent person would have paid in that circumstance.
Thank you. I'm going to press you, Mr. Jackson, and I don't mean to be disrespectful, but I am going to press you, and I'm going to use a different analogy or example than what Senator McKinney used with our last witness, but similar. If you came to me and you asked me to build you a house, and it was going to be a 12-bedroom house with a pool in the back and a tennis court, and I said, I can do that for $50,000, and you were using state funds, would you say to me, well, the taxpayers aren't getting swindled, so I guess that's reasonable?
Council, I'm afraid I don't follow the hypothetical. Again, all my subject matter expertise, to whatever degree I have it, is just generally how does procurement law operate. That's how DAS shows up in terms of our consultation and partnership with our agencies. I believe that's how policymakers should want it. Again, I don't believe policymakers should want a gubernatorial appointee in administrative services reaching down and overruling subject matter experts in our agencies that are most intimately familiar with the services or what they should cost. So I'm not sure about the house construction, but that's just my general answer in terms of how I would hope we would conduct ourselves and what I believe policymakers ought to want from how our agencies are showing up in circumstances such as these.
Thank you, and I appreciate that I was pressing there and giving you, a hypothetical that, to me was pretty preposterous. But I think for folks on the committee and certainly myself, that the bid was 40% below the next highest bidder, I think is, for me and my definition of reasonableness, does not seem reasonable. That these services could have been provided for that cost in light of the Stephen Group report and other factors. And so I think the committee is looking, for any check in the system where there is a check on the subject matter experts to say, look, are you really considering whether the services can be provided for the amount bid? And I think, I'll just pause and let you respond to that because I don't want to put words in your mouth, but it sounds to me like DAS doesn't believe that that is appropriate. And that's okay. I just want to understand if that is indeed the belief of DAS. We're not going to second guess our subject matter experts regardless of cost, as long as the cost is not too high.
Yeah, and well, forgive me for being, I don't know, perhaps a little guarded, because you're using some language that's unfamiliar to me, and we're covering hypotheticals, and I take the seriousness of being under oath pretty seriously. Your question is, I take your question to mean, does DAS provide any guardrails on a reasonableness assessment of cost? Again, from the process perspective, we would insist that the process is conducted and the process has guardrails on cost. The criteria provided, the weight afforded it, we need to make sure that that is met. That the actual math of how it's conducted, again, is objective and fair and transparent for everybody to see. So to the question of, are there no guardrails, or what is DAS's role in providing guardrails? Those are the guardrails that I identify. I think DAS has a role in that. When you're using words like reasonableness that have a very clear legal meaning in procurement law, I just think it's important to be precise about that. And so that's how we take that to mean. That's how we apply it at DAS. And again, I think generally speaking, that's what the legislature would have us do. The legislature isn't interested, and I know this is a very high profile, volatile, important, and but again, we handle 700 contracts in total at $6 billion. That's a high level of public trust. 200 contracts a year. And so I'm burdened with not only, of course, being interested in this specific contract, but also just generally our procurement policy, so the system as a whole works well. I understand that to be the interest of the committee as well. And I don't think it would be consistent with legislative intent to say we shouldn't be assessing reasonableness based on a standard of people charging the taxpayer too much. And what's more, again, that's when we lean into from a contract law perspective, and that's the standard we apply at DAS. And that is interwoven into the actual evaluation process. So that's what I would say is DAS's role in that assessment.
Thank you. Do the same guardrails that DAS applies or has, the term guardrails, do those same guardrails apply in terms of the procurement process and cost as it relates to costs being too low or too high? Would you apply those the same way?
I'm not sure I understand the
Do
question.
the guardrails that exist, do you believe the guardrails that exist guard against an award that is too low?
Okay. Okay, so what I understand your question to be is there a guardrail against a bidder basically artificially submitting a bid that is too low? I think the guardrail that would exist in that instance would have to be, again, the subject matter experts in the agencies. I think I've spoken at some length at this point about how DAS procurement professionals would be ill-situated to know exactly what the market should bear and how much a service should cost, absent the subject matter expertise of the agencies themselves. And so again, the procurement process calls for, and the evaluation process calls for, the agency to do that evaluation. And so if there were a defect to that extent, I would have an expectation that the agency evaluator would identify it. But again, as I think the testifiers earlier today said, they looked at the reasonableness. There was this question as to whether or not they compared it to their services in their own organization. Those were facts that were unaware to me, but to me that seems to suggest the system working as designed, that the agency subject matter experts that are the most familiar with what the cost should be would form a judgment based on the information available to them about whether or not the cost was reasonable.
Are you aware of any instances where DAS has ever rejected the lowest bidder?
I'm not personally aware.
Mr. Jackson, are you, would you agree with me? Well, I won't make you agree with me. Are you aware of the testimony that was provided to the HHS committee in January of this year, where I believe St. Francis indicated that the contract was indeed underbid? Are you aware of that testimony?
I didn't watch the hearing and I didn't see any testimony.
Do you have an understanding, sitting here today, that the RFP by St. Francis was indeed underbid?
Yes,
Because they came to this committee and asked for an emergency contract, right?
I
You're
can't
aware
say
of
what
that?
the foundation is for my belief about that.
Okay, so did anyone in DAS at any point in 2019 indicate to you that they knew that the contract had been underbid? That
Not to my
St.
knowledge.
Francis, I'm sorry, let me just clarify.
Mhm.
Did anybody in DAS indicate to you that they suspected that St. Francis had underbid the contract?
I don't have any recollection of anybody giving me that indication.
I think with that, and in an effort to move forward and make sure the committee's questions are also asked, I'm going to pause. I don't think I have more questions, but I'll turn it over to Chairman Arch for maybe some additional questions.
Thank you. Senator McKinney.
Thank you. Thank you for your testimony.
Yes, sir.
I know you said that cost was only 25% of the whole thing, but still cost could have been, the 25% could have been higher than everything else. It's just 25. The cost was just not the majority technical. And I want to try to put you in the shoes of somebody with a kid that's in the foster system. So just imagine that I am you and your kid is in the foster system and you're curious about the case management and everything that goes on. So I guess my question is, would you as a parent or as a taxpayer care more that St. Francis could properly manage the cases or do the work at a lower cost?
Yeah, so you're asking me to opine about what I would care more about as
Yes,
a parent.
yes.
Okay.
Or a taxpayer.
Yeah, well, I mean, yeah, so I am a parent. I think, Senator, we've gone through some length and to be authentic and sincere about the care and the importance that we place on the service to the children. To the question, so the question is, should cost, would the care be more important? Absolutely. And I think the evaluation here reflects that. The total care, the total program was 75%. The cost was 25%. And again, that would have originated from DHHS. They would have decided that criteria. They are closest to the work. They care intimately about the children they're caring for. And so they would have decided what level of prioritization to apply to cost and then how to grade that and relative to the services that they were providing.
So do you think we should be looking at the scoring system? Because from what I've gathered today and from what I understand, although care is supposed to be prioritized higher than cost, it seems like although Premiership probably scored better in being able to manage cases and take care of kids better. The fact that St. Francis may have not scored as high with care as Promise Ship, the fact that they submitted a proposal with a 40% lower bid outweighed all of that. Do you think we should definitely fix our scoring system?
Well, so the scoring system is subject to the judgment and the discretion of the agency that's engaging in the service. So it's not a 25% calculation in all circumstances. And the agency that's procuring the service, again, decides what their criteria of evaluation is, and then how much weight to give each of those criteria. So in this instance, DHHS decided that, yes, the care for the children, it was the overwhelmingly most predominant aspect of their RFP, and that was 75% of the weight. The cost component was 25%. St. Francis was close enough in proximity to Promise Ship such that the cost was the differentiating factor. But in my role as DAS director, I'm responsible for the system as a whole and the 200 contracts that we do every year. And I'm deferential to the judgments of our agency subject matter experts that are responsible for the programs for determining what weight to give.
And I understand that the CEO Smith earlier stated that DAS makes the recommendation and it's not them. So I guess it's who's responsible. Who you or her?
Yeah, I didn't catch CEO Smith say that. What I understood her to have said is that the DHHS makes the recommendation based on their evaluation, which is true. They decide how much weight to give each of these factors. They do the evaluation, and then they make their recommendation on bid award based on that. Your question gets to, hey, are we placing too much emphasis on cost? And my response to that is the process allows agency directors to determine for themselves what weight to apply to that specific contract. And it's entirely foreseeable. Again, I know you're interested in this St. Francis contract specifically, but I also understand you're interested in state procurement more generally. I think it's entirely appropriate that agencies have the discretion to decide in any particular instance what weight to give cost. In some cases, cost may not be a factor at all. I don't know. Or it may be a very small factor. In other cases, maybe their budget is tight, the service not particularly critical, and cost is the predominant factor. Again, I wouldn't substitute my own judgment for their expertise about what they're trying to accomplish and what their resource limitations are. And so that's why the process, I believe, is designed to give those leaders who are most accountable for the results the discretion to make those determinations.
So would it be fair to say that the department made the decision and you just followed their direction?
I think I spoke to that when Ms. Jensen raised the question earlier. I really look at it as a collaborative process. DAS is responsible for the fidelity of the process. CEO Smith and DHHS as an agency is responsible for the evaluation. It's like air, food, and water. We can't have one without the other and live. These things go together. There's a mutual dependency. And what's more is that's how we show up as a team. We show up in a collaborative sense with the expertise that DAS brings to the table is for the process. The expertise that they bring to the table is the actual evaluation and child welfare. And I believe that's how policymakers should want it. Again, that places a veto with both parties consistent with legislative intent. Again, there's this legislative intent that the process be fair, objective, transparent, and performance-based. We own making sure that's true. DHHS is best positioned to own the actual outcomes with child welfare. And so we both need to come together with a mutual agreement on this contract.
All right, thank you.
Thank you, sir.
Other questions? Senator Kavanaugh.
Thank you. Thank you, Mr. Jackson.
Yes.
Okay. Is there a typical cost percentage when in all RFPs across the board for the state? Is there an average of how cost is weighed, what the percent is? You said it was 25% in here, and I will actually correct, it is not 25%, it is 28.4%.
Thank you.
28.6% in this particular RFP, but I'm sure you just estimated, but is there an estimate of what it averages typically?
I don't have that estimate at my fingertips, but that is knowable to us. So my team can go back and look at, just generally speaking, what is the general percentage that cost is applied across the breadth of our country.
Would you say that this will probably fall in the middle of the road, at the high end or the low end?
I wouldn't hazard an
Okay.
estimate because I don't.
All right, I will wait for that information. You have mentioned both to legal counsel and to Senator McKinney, and I apologize because I haven't quite followed the flow here. You said both parties have veto power. You don't think that it's appropriate for you to overrule. And then there's the whole scoring process and the tabulation. And doesn't seem like anybody knows who's responsible for fact checking. And I understand that you're talking about the contact experts, which is DHHS, but the RFP is online, available online. The scoring, how its scoring is tabulated is also within that document, correct?
Yeah, I believe the tabulated scores, the evaluators' results of their evaluation is posted online and available there.
But how it is tabulated in advance, like during the RFP process. RFP man, like the whole RFP says cost is this, tabulated this way.
It's my belief that the bidders have advance notice of what the percentage of the evaluation is, but I am not certain of that. So if you'll afford me a little grace, I'll make sure and look into that.
I believe it's on page 50 of the RFP, but I wasn't able to pull up the RFP, so I can't say that for certain either. Okay, and then the previous contract for Promise Ship and the amount of that contract, that is also publicly available?
It would be my expectation that all contracts are publicly available.
I apologize, I don't know, I'm not a lawyer.
Yeah.
Do you have a law background?
I do,
Okay.
not a very accomplished one, but
Well, I'm not here to judge that, but in the law, there is, as we've talked about here, a responsibility and due diligence, et cetera. If it is known that how the scores are calculated is online and what the contract amount has been is available online, and somebody comes in with a 40% underbid who wasn't on the vendor list to begin with, what do we do to make sure that that is actually vetted? Because nothing that we've been told today by any party is that there's a process to vet that. And that, to me, it's like, it's clear that should have been vetted. So what do we need to do as legislators to change that?
yeah, I'm uncertain. It's a very thoughtful question. I think I heard some of the earlier testimony cut a different way. So, from my own perspective, like I said, this cost assessment and the actual ability of the bidder to conduct the work is interwoven throughout the evaluation process. What I heard the earlier testifiers say was that they did evaluate that. I heard specifically that there was a sense that Promise Ship was in some history of service delivery for Promise Ship, they felt like they were spending too much, that they had formulated a basis of that understanding from their own knowledge of what child welfare should cost for those areas of service that they're specifically responsible for, and that had informed a judgment on their part that it was reasonable. That's what I understood.
Can I clarify that point? Because it was Mr. Patello that said that.
Okay.
But he actually said that that was his impression from Mr. Wallen, and Mr. Wallen has not testified to that. So
Okay.
I just want to clarify that we don't actually have verification that Mr. Wallen thinks that we were paying too much to Promise Ship.
Understood. Okay. Well, presuming the testimony that you heard was accurate, that would comport with my expectations about how subject matter experts at the agency are assessing cost, and basically, are they getting what they're buying? And is the vendor that they're working with capable of performing the service? And that's interwoven throughout the evaluation process.
So, but what we did hear today is that it actually wasn't interwoven. They asked them if they could do it, and they said yes. And that was it. And there wasn't a financial audit done. There wasn't a performance audit. There wasn't a risk assessment. all of those things that are supposed to be done were not done in advance of entering into the contract.
Those are facts unknown to me, so I couldn't speculate as to.
I'm accurate in what I'm saying, I believe.
We've heard a lot of testimony.
Yeah, sorry. So I'm sorry, and I don't want to take up too much time, but I'm just trying to figure out, and while we have you here, I'm hoping that you can help me understand, because I spend much more time with DHHS than DAS. And so I just, again, I go back to what can we do? Because there's something happening, there's a disconnect happening where you believe that DHHS is doing something and they believe that, oh, this looks good, we will make this recommendation. You will probably vet it and tell us if it's bad or not. Like, where does the buck stop?
Yeah, again, so if you'll extend me a little grace of being conversational. To me, I think this is a core question that your committee is analyzing. As I've reflected on this question myself, I would hope the committee would have some empathy for the hindsight being 2020, that there is now facts in the record that you have at your disposal that were not at the disposal of the decision makers at the time of this contract. And based on the facts that were available to them at the time, this was a very defensible position. And just to kind of illustrate this, I mean, something I've thought about subsequent is imagine the alternative hypothetical. Imagine that there's an RFP, 2 bidders respond. Both of them believe the process to be objective and fair. They have foreknowledge about what should be included in the RFP. They make a price recommendation based on the price they think they can provide it for. The state does an evaluation of it using objective criteria that are known to everybody in advance. And then the state preferences an incumbent bidder and selects the losing bidder at the expense of another provider that was going to charge the state $40 million less. To me, based on the information that I've seen that was available to the decision makers at the time, it's very hard for me to put it. That would have been a scandal. That's not a defensible position. What's more is the results of that decision, if that would have been the preferred result, are entirely predictable. St. Francis would have sued instead of Promise, and they probably would have won because the facts would have indicated that that was an arbitrary decision at odds with an objective evaluation process. And if I might, I'm not attempting to be glib, but I'd probably be here in front of a special investigative hearing today trying to explain why we wasted $40 million selecting a bidder who was so obviously lower when all the objective information of the subject matter experts in the agency indicated that the alternative choice were the appropriate choice. The membership of this committee would probably be different.
I could answer that question for you.
Okay.
The department had a cost analysis done when they were forming the RFP that told them that the cost that they were currently occurring from Promise was an appropriate amount, that it was equal to what the state would be spending if the state was doing it themselves. So we did know, we had a document, we commissioned this document, and everyone had it saying that the cost that Promise bid was accurate. So that's the first very large red flag, is that there's a 40% underbid and we know it's an underbid. We don't have to know anything else. We know it's an underbid because we asked what it costs to deliver these services. And so how do we make sure that we don't ever do that again? Because it's also costing the taxpayers way more than $40 million right now.
Those facts are unknown to me. I guess I would just have to hope that a court, when St. Francis were to sue, would find that argument convincing. But those weren't facts that were available.
But I'm asking, moving forward, how do we stop this from happening again? How do
Can
we
you be
get
more specific?
How do we get DAS and the, I can't remember what you call them, the other agency that's participating, how do we get them to the point where they are talking to each other and making the decision in tandem, not taking a recommendation from one and accepting it without in-depth conversation as to, is this appropriate? How was it vetted? I see that there were individuals that were hired to score, and I see that those scores were tabulated, and I see records of some of the evaluators asking if they could check up to see if things could be done, and they were told no. I don't see any point, and I'm sorry, I will stop here because I'm carrying on, but I don't see any point in which there was communication about validating the application. And since you're the one that deals with the RFPs, I put it to you, and you don't have to answer it today. I don't want to take up the rest of everybody's time, but
Senator
do think
Kavanaugh, I would say that's certainly going to be one of our deliberations.
yes,
Is an answer to that question.
thank
So,
you.
Thank you.
If I may, I guess I would just, I think the record shows that there was collaboration. I think the testimony of me and my colleagues suggests a collaborative approach. If your question is specific to, hey, is there a legal remedy for a bidder who has dramatically underbid a contract? The answer to that is yes. The legal remedy is that we cancel the contract. And 99.9% of all circumstances. So again, you're asking me to be here because of my expertise in the system, not in child welfare and the contracting system generally. The state's remedy, if a vendor underbids a contract and then subsequently can't perform it, is to cancel the contract. And
That's a tough remedy. We've seen that in the past with some contracts. I guess I would say that from what the testimony I've heard today from you is that it's tough not to accept a low bidder.
I think that's a fair characterization.
Yeah. And sometimes we have accepted low bidders and then we've had to cancel the contract and it has not gone well. But I think particularly of Wipro, when that happened and they were accepted and there was another bidder, this is my understanding, and we got into a similar situation. So
I'm not familiar with the circumstances of the Wipro contract.
okay. All right. Any other questions? Seeing none, thank you very much for your testimony today. Do you have some closing remarks?
Yeah, thank
would
you,
like
Mr.
to
Chairman. I understood that I'd be afforded an opportunity.
Yes.
I would caution the committee that I think the line of questioning and the interpretation of the facts that I've experienced, and I think my colleagues experienced, seem to presume.
Seem what?
Seem to presume that seem to cut specifically in favor of Promise-Ship having prevailed in the bid. And what's more is the line of questioning, the interpretation of state contract law that I've kind of heard as I've seen the committee's work today seems to, I think, would aid a very specific special interest, and that would specifically be big law. And big law has been trying to uncrack our state statutes so that more contracts could be subject to litigation for many years. I think Senator Coulterman spoke to that. That would have, I don't particularly have any dog in that fight. I'm not at all territorial about this. It would be a lot more comfortable for me if I could just point to a judge and say they decided. I don't think that should be what the committee is interested in. However satisfying or unsatisfying this has been, at least you've been afforded an opportunity to hold leaders like myself accountable for the decisions that we've made. And if we were to open up our procurement process and our protest process specifically to litigation, that would basically absolve leaders like myself for any accountability for this and further remove the decision-making process from that of the actual subject matter experts. What's more is that would advantage specifically incumbents. It would advantage the types of corporations that have large dollars, large resources, and large social capital. it would accrue to the detriment of the little guy. It would accrue to the detriment of rural business. It would accrue to the detriment of small business. It would accrue to the detriment of minority-owned business that doesn't have the same access to resources, legal counsel, and social capital that incumbent and large players in the marketplace do. I heard some earlier testimony about, hey, do we believe or have we thought about a reform to the protest process? And does our current protest process presumably deter market participants? Actually, we think about this all the time. That's why we oppose that legislation, is because it would specifically shrink the number of market participants. Our protest process is objective. We take it seriously. As I mentioned, if we're assessing the breadth of our state contracting system, 200 contracts a year, only 2 to 3% of which are protested, and we sustain those protests 25% of the time. That's a quasi kind of just being conversational legal review that affords any market participant, regardless of their size, sophistication, access to legal resources, money, whatever, an opportunity to be heard and to fairly adjudicate their decision. I fear that if this committee were to take into account a reform, not just of the procurement process, but also the protest process, it would jeopardize that and really narrow our procurement processes in the favor of those large corporations and large bidders that are most advantaged by cumbersome legal processes and lengthy legal reviews.
Thank you for your testimony.
My pleasure, sir. Thank you all.
With that, we would ask Bill Clark if you would be willing to come up.
Sir, how are you?
Welcome. I'm sure you're aware we're swearing in our testifiers today, so if you would raise your right hand. Do you swear or affirm that the testimony you are about to give to this committee is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Thank you, Mr. Clark. Nice to see you again. We have met previously. So as you know, I'm Marty Jensen. I'm special counsel to the LR 29 committee. Mr. Clark, I didn't see you present earlier this morning, but were you at least listening to some of the testimony this morning?
I was able to view the entire testimony.
Okay, thank you. So you heard our process, but I'm just noting again that we may constrain you at times. I may interrupt you at times, but I do want you to be thorough in your answers. And I know it is getting late in the day, but with the committee's permission, and especially the chairman's permission, we do want to give St. Francis an opportunity to fully answer the questions and present the testimony that you may have prepared today. So I'm not in a rush, even though it's exactly 4 o'clock as we get started. I know sometimes going last makes you feel like you don't get, a fair shake. And I want to make sure that you understand that's not going to happen, even though we're late in the day. Mr. Clark, we are giving St. Francis an opportunity to make some opening remarks, just like the other witnesses, Ms. Smith and Mr. Jackson. We ask you to constrain those to 5 to 10 minutes if you have any. I'll ask if you would like to begin with some opening remarks.
Yes, ma'am, I do have some. I would like to proceed with those.
Yeah, please proceed. Thank you.
Chairman Arch and members of the Health and Human Services Committee, and especially appointed Legislative Committee, I do appreciate the opportunity to present today. My name is William Clark, spelled WILLIAMCLARK, and I currently serve as the interim president and CEO of St. Francis Ministries. Much has transpired since the last time I addressed the HHS committee in January of this year, so I do value the occasion to be present today. As I begin my remarks, please know that St. Francis Ministries has remained committed to providing full service case management to the Eastern Service Area. This commitment has not wavered during unprecedented and turbulent times. In January of this year, I addressed the HHS committee and owned that St. Francis submitted a faulty bid when it bid in the ESA contract in 2019. Simply put, the bid was bad. The work to prepare the bid was not accurate. However, the contract was not maliciously underbid by St. Francis. Speculation and false allegations of this nature are both unfounded and damaging. This form of rhetoric is simply false, not productive, and unnecessary. Clearly, there were errors in judgment by past senior leadership of the organization. However, the St. Francis today cannot correct what transpired more than 2 years ago in the bidding process. We at St. Francis have moved forward from this topic. The topic of gross mismanagement has also been addressed. We have been open and transparent about the situation, to include addressing the HHS committee in January and sharing reports with that committee and the Office of the Inspector General. To reiterate, those involved in this topic have been removed from the organization, to include the former CEO, COO, General Counsel, and CIO. Additionally, the St. Francis Board of Directors has changed processes and procedures relating to governance to ensure nothing like this happens again. Much work has been done in this area during 2021. As part of this effort, the Board of Directors have changed. New board members have been added, and another has departed. Audits have been conducted and have shown that St. Francis did not use state funding for any nefarious personal type expenses. Rather, those costs were levied against the organization's foundation. In January, I also articulated the financial mismanagement of the organization, the repercussions of that mismanagement, and the major areas of financial concern that St. Francis was immediately facing. Today, we are at a place of financial stability. Our monthly cash flow clearly indicates this stability. At this point in time, our focus in the Eastern Service Area is truly on providing healing and hope to children and families. In other words, on program delivery. One of the main points of contention with St. Francis has been our inability to meet the caseload ratio required by statute. We agree that the best outcomes for children and families are more readily achieved with low caseload ratios. However, this caseload ratio requirement has never been met by entities within the ESA. Caseload ratios have consistently been a challenge within the ESA and throughout the child welfare industry as a whole. Just as it is today, employee recruitment and turnover are the primary reasons for this problem. Truthfully, this challenge is nationwide across child welfare. The American Network of Community Options and Resources, in their recent 2021 State of America's Direct Support Workforce Crisis Survey, stated that 77% of providers are turning away new referrals, which is a 16.7% since the start of the pandemic. 58% of providers are discontinuing programs and services, a 70.6% increase. 81% of providers are struggling to achieve quality standards, an increase of 17.4% during the pandemic. 3 of 10 providers report spending at least $500,000 annually on costs associated with high turnover and vacancy rates. And 92% of providers report that the COVID-19 pandemic continues to complicate their stability and their ability to recruit and retain qualified direct support professionals. Even with that, St. Francis is meeting the contract metric of 95% of monthly face-to-face contact with youth, the key statistic that is more aligned towards safety and preventing maltreatment. On average, workforce turnover within child welfare profession is more than 7 times the national average when compared to turnover in other professions. The historical challenge of workforce stability are being compounded by current events. Despite a concentrated effort by St. Francis to attract and retain case managers, personnel shortages continue to be the central issue that impacts contract performance. The state's unemployment rate, according to the Nebraska Department of Labor, in August of this year was just 2.2%, which is 3% lower than the national unemployment rate of 5.2%. The reality is, however, is that negative unemployment exists in Nebraska. Work in all fields are not readily available. Workforce availability is our greatest challenge. St. Francis has been aggressive and innovative in our hiring strategy to combat this unprecedented employment environment. These efforts have included multiple hiring fairs, employee retention bonuses, referral bonuses, bonuses for fully trained case managers, performance bonuses, salary increases, establishing a mentor program, and social media campaigns, just to state a few. With all that, we still continue to explore all options to adapt and expand our hiring process to the employment environment of today. Also of note, under the contract for the Eastern Service Area, DHHS is allowed to retain payments to St. Francis if certain metrics are not met. DHHS has chosen this option and is currently withholding nearly $2 million in payments due to St. Francis. This is money that could be used for hiring bonuses, retention bonuses, and the like to help solve the employment challenge. In these times of unprecedented challenge, all avenues to correct employee shortfalls must be utilized. The state as a whole is weathering the same challenge and is using large recruitment bonuses and other benefits to attract and retain employees. Numerous requests to DHHS have been made regarding releasing the retained funds in order to provide necessary funding for attracting and retaining employees. Additionally, current pay rates must be adjusted to keep and attract employees, or social welfare organizations will continue to lose employees to other entities, such as Costco and Walmart, whose pay structure is just simply higher. To date, the requests to return the retained funds have not been honored. Solving the challenges at hand requires a sufficient workforce. The key ingredient is currently absent. A continued non-flexible approach towards solving personnel challenges will only result in the status quo. The pandemic's impact on this world has been immense and must be considered. In Nebraska, turnover rates reached new monthly highs that were 2 or more times higher than historical measures during the first half of 2021. The pandemic was and continues to be a significant barrier across the state for hiring and retaining a sufficient quantity and quality of qualified staff. COVID-19's impact on St. Francis's ability to perform services continues as of today. There is no question that St. Francis is not satisfied with our current performance. We will always be committed to improving outcomes. However, children remain safe today in the Eastern Service Area. The commitment and dedication of the St. Francis team members and the ability to shift resources in an unparalleled environment shows the power of a privatized system. Even with the challenges just mentioned, the Annie E. Casey Foundation, a national nonprofit devoted to developing a brighter future for children and young people, ranked Nebraska children as 7th in the nation in overall child well-being. By way of comparison, in 2014, the foundation ranked that Nebraska was ranked 10th nationally and 9th just last year. With St. Francis responsible for 45% of children in the state welfare system, St. Francis' performance has had a significant positive impact upon this improved ranking. I will conclude my opening remarks just as I began. St. Francis owns its mistakes. We have remained committed to providing full-service case management to the Eastern Service Area. Throughout the unprecedented conditions of the COVID-19 pandemic and historic employment challenges across the state and country, St. Francis has remained steadfast and dedicated to the work at hand, providing healing and hope to children and families. At this point, I stand ready to answer the question.
Thank you, Mr. Clark. Marty?
Yes, Mr. Clark, I'm going to start, as I have with all of our testifiers today, with some background questions. When did you join St. Francis Ministries, which I will just call St. Francis?
Yes, ma'am. I became a member of the St. Francis team on November 1st of 2019.
And what was your role at that time?
My role was as the chief of staff, and in my purview, I was responsible for support type services of the organization. That included facilities, safety, security, risk management, transportation, HR, IT, and quality assurance.
And so did you have any role in the development of the original RFP response that was submitted by St. Francis?
No, ma'am, I did not.
And did you have any role in the submission of any materials in 2019 that St. Francis provided to DHHS with respect to the award or the contract, anything, understanding that you did actually work at St. Francis in 2019?
No, ma'am, I did not.
Prior to joining this as chief of staff in November 2019, did you have any relationship with St. Francis in your prior role?
I previously served as the president of St. John's Military School. St. John's Military School merged with St. Francis Ministries in September of 2019. I knew the leadership of St. Francis Ministries at the time through that merger.
Okay. Prior to that merger, did you know Tom Blythe?
I did, as we were in the same town.
So you know him personally, but not professionally, or?
Prior to starting the merger work, I knew him professionally.
And the same question with the individual who I think everybody knows as Father Bobby. Did you know Father Bobby prior to you coming on as chief of staff in November 2019?
I knew that he was the president and CEO of St. Francis, but nothing personally.
And what is your current role at St. Francis?
I currently serve as the interim president and CEO of the organization.
Is there any, view toward taking the interim off of the interim role for you?
I think that's a decision by my board of directors.
What duties do you have as the interim CEO?
I'm responsible for all facets of the organization, program delivery to financial and personnel management to all support services, and that falls within the corporation.
When did you assume that role of interim CEO and president?
Approximately the 28th of October of 2020.
Mr. Clark, what steps and actions have you taken to prepare yourself to give your testimony here today before the committee?
I have met with select former employees along with the organization. I have met with current leaders of the organization who have knowledge of the process, and I have reviewed some internal investigative reports.
Can you please share who the former employees with whom you met to prepare for today?
The former vice president of programs, Diane Carver.
Ms. Carver, who I think you probably heard us discuss
Yes,
earlier.
ma'am.
Good. Well, I'll save those questions. So good to know that you've spoken with Ms. Carver. Did you share or discuss any of the questions or topics provided to you in advance of the hearing with any representatives of the state, specifically with DHHS or DAS?
No, ma'am.
There's been some discussion, I think, relating to the requests for information that were propounded from the committee to St. Francis. Are you aware of those requests for information that were submitted to St. Francis from the committee?
Yes, ma'am.
And were those requests for information, and just so that everybody understands, some of those were submitted informally and some of those were submitted through subpoena. Is that accurate?
Correct.
And I just want to clarify with respect to both of those categories, and I'll lump them together. What did your office, what did St. Francis do to identify, review, and prepare documents that then were submitted to the committee?
When we first received, we'll say the informal request, we met with members of this team to include yourself to review to make sure there was clarification on what was being asked and required. Once we completed that, we assembled our leadership team to go through the requirement. We divided who had what responsibilities. They then in turn collected documents that were required, submitted them to the organization's legal counsel, who became the point of contact for this effort. That included our IT department going through and scanning the system, doing some manual checks. Once the information was put together, it was then in turn submitted accordingly.
And I think I asked this, but that is true of both documents responsive to the informal requests and to the subpoena.
Yes, ma'am.
With respect to the information available to the committee, I do just want to clarify with respect to the subpoena, did St. Francis did St. Francis perform a good faith search for internal communications between its former CEO, former COO, that's Reverend Smith and Mr. Blythe, and the state of Nebraska?
Yes, ma'am.
And anything that was discovered, was that provided to the committee?
Yes, ma'am.
Mr. Clark, are you aware of any instances where responsive documents may have been destroyed prior to the committee's request of the subpoena being received by St. Francis?
I have no knowledge of anything being destroyed.
There's been, and destroyed is perhaps a tough word, so let me kind of ask the question a different way. In some of the documentation that's been provided to the committee, there is a discussion of a loss of documents related to some IT issues or server error. I'm not trying to mischaracterize it, but can you speak to your knowledge with regard to what documents, if any, just simply may not have existed at St. Francis?
In November of 2019, St. Francis had a server crash in which a substantial amount of documentation was lost. What was inside of that, I can't attest to. We have worked diligently on the financial side to rebuild that, to make sure we can comply with financial statements, audits, and so forth.
And the timing, it was November 2019. Did that occur prior to you joining the organization, or at the same time, or after?
It happened at the same time. I started on the first, if I remember correctly, the server crashed on the 4th.
That's helpful. Mr. Clark, do you believe that St. Francis has fully complied with its obligation to provide information pursuant to the subpoena to this committee?
I do, yes, ma'am.
Without reservation?
Without.
Mr. Clark, I am going to move us into some specific questions about the procurement process. I know, and I'm familiar with your testimony from January, and I think, I'm speaking for myself as special counsel, I appreciate the, I think, directness with which St. Francis, and you in particular, has taken responsibility for the bid. I think you've handled that very directly, but that doesn't mean we don't still want to ask you questions about that and understand how we got to where we are today and also where we were in January of this year. So I'm going to start by asking whether St. Francis, and before I do that, I do want to clarify. I understand that you were not there for the RFP response based on my understanding, but also what your testimony was today. But the subpoena for testimony today was directed to St. Francis. So when I'm talking to you, I really am asking for St. Francis's knowledge, understanding that you probably don't have your own, having not been there, but I do want to encourage you to answer my questions on behalf of the organization. That's the entity subpoena today.
Yes, ma'am, I understand that.
Okay, thank you. So did anyone at the state of Nebraska ask St. Francis to submit a bid in response to the RFP?
To our knowledge, no. St. Francis was doing work in western Nebraska and became aware of the opportunity.
Did you have did St. Francis have an understanding of that there had been a vendor list prepared with respect to the RFP?
No, ma'am.
Regardless of whether, well, I'll set aside, assuming there were no conversations affirmatively requesting St. Francis to submit an RFP response, were there any conversations between DHHS and St. Francis prior to St. Francis's RFP response about the RFP response, setting aside Western Services?
Not to my knowledge.
I'm going to ask, with respect to Senator Kavanaugh's questions that she submitted to Mr. Jackson, was St. Francis aware of how much weight would be given to the cost portion of the RFP at the time it submitted its original RFP response?
I was not aware. I have not discussed that with my team members.
And this, a similar question, whether St. Francis was aware of the costs that Promise Ship had been providing those services for leading into the RFP.
I do not know if they were aware or not. I was not.
Okay. And I know those sort of came up today. We may ask you to
I
provide
understand
some additional answers after the hearing with respect to those. I think it is, an important issue that's sort of come up this afternoon that I think would be curious with St. Francis's knowledge on those two items. But getting into the submission of the bid, was St. Francis aware of Nebraska's procurement manual prior to submission of its RFP response?
Not fully. St. Francis understood the requirements in Western Nebraska from a provider CPA perspective, not necessarily from a lead agency perspective. Elements of the procurement manual were reviewed, but not in totality.
And what, if anything, did St. Francis team members do to familiarize themselves with the manual and the processes that were going to be used during the RFP process?
There were select team members who, as I mentioned, would review parts of the procurement manual. There was a team put together to develop the RFP. That team also conducted a site survey. There was select members of that team up to Nebraska, specifically the Eastern Service area, to speak with providers who were serving in the ESA.
What agency did St. Francis believe was the decision maker?
St. Francis believed that DAS was the decision maker.
What was that based on?
Previous experience in other states, what St. Francis had seen prior.
Was there an understanding at St. Francis that DHHS was the evaluator?
Understanding in St. Francis was DHHS was really responsible for the programmatic or operational aspect of the contract. The decision for the contract itself came from DAS.
Okay. And did St. Francis have an understanding? You've heard some testimony here today, and I think maybe we still don't have the answer as between DHHS and DAS, but what did St. Francis believe DHHS's role was with regard to the decision to award? I understand you were talking about sort of program management once it is awarded, but what did St. Francis understand DHHS's role was in the award?
I'm not sure St. Francis understood what their role was in the decision-making process.
Was St. Francis aware of the Nebraska statutes governing caseload ratios prior to submission of its RFP response?
No, they were not.
When did St. Francis become aware of the statutory caseload ratio requirements?
They became aware in two times. One, when Promise Ship voiced an objection. And the second time was when a negotiation process with DAS, DHHS transpired.
So just to clarify, Promise Ship filed a bid protest on June 14th of 2019. I will characterize it as sort of highlighting the 25-to-1 caseload ratio that St. Francis's bid contained. And so was that, for St. Francis, the first time that St. Francis understood that 25-to-1 caseload ratio did not meet statutory requirements?
Correct.
And then you mentioned in the sort of contract process, and we heard Mr. Patello's testimony. Are you specifically referring to the process that led up to the clarification meeting in June of 2019?
Correct.
So just general overview,
Mm-hmm.
How did St. Francis prepare its bid? What went into that? What effort went into that?
As I mentioned, they assembled an RFP team. That RFP team consists of team members from the program side, finance, HR, training, systems improvement. Select members of that team then conducted a site visit to the Eastern Service Area. They met with providers to gain a better understanding of the environment and expectations. They then came back, a team reassembled, and upon reassembling, they then worked to create the RFP.
Mr. Clark, do you believe that St. Francis understood the RFP requirements at the time it submitted its bid?
I do not. I believe that when St. Francis put the RFP together, they really looked at their experience in Western Nebraska from a provider perspective rather than as a lead agency. I think that St. Francis has learned that the work in Nebraska is different than the work in Kansas and Texas, for example. The RFP St. Francis was put together quickly. Consultants or experts were not utilized in the forming of the RFP. Clearly, there was some due diligence that was lacking when they put the RFP together. From the program side, those members that I've spoke to, they believed that they were creating an RFP that would introduce St. Francis to the state of Nebraska, really from a case management perspective.
Do you believe that did St. Francis understand the historical costs of providing services in the ESA at the time it submitted its bid?
They did not.
Internally at St. Francis, did St. Francis anticipate a loss on the Nebraska contract as a result of its bid?
Can I take a step back and clarify the last question just a bit, if that's okay with you? The answer is still no, but I think there's a further explanation to that if you wanted. St. Francis did not understand what we refer internally as a 65-35 rule. There was an expectation that the work would be done internally rather than having to take 65% of the work outside of the organization. So they did not understand the cost concept. As far as your question regarding did St. Francis expect a loss on the contract, the answer is yes.
And what, if anything, did St. Francis, was there a plan to mitigate that loss?
I don't believe at this point I'm in the position to answer that. When the RFP was put together, there was discussions once they found that the intent to award came to St. Francis. There was recommendations by team members not to move forward because of the financial concerns.
So let's talk about that. To whom were those recommendations made?
CEO and COO.
And obviously those recommendations were not followed.
Correct.
And do you know who made those recommendations?
They came from the program side as well as from the finance side.
Did anyone at St. Francis, any individual at St. Francis at the time the RFP was submitted, stand to personally benefit financially from securing this contract?
Absolutely not.
Did anyone at St. Francis at the time of the intent to award have personal or business relationships with any Nebraska state employees that were involved in the award decision?
No, ma'am.
Did anyone at St. Francis at the time of the intent to award have any business relationships with any Nebraska governmental officials?
No, ma'am.
At the time of the award to St. Francis, did St. Francis consider itself a responsible bidder as defined under the Nebraska statutes?
Yes, ma'am.
And what was that based on? How is that, I guess, determined?
When you go back and look at the definition of which I reviewed, I do have a copy of it in front of me. And when they look through the characteristics of that, which is much deeper than just the cost perspective. There's really the top 5 aspects of that. When they looked at themselves from performance, ability to perform and so forth, they saw themselves in the responsibility.
Today, so that was at the time of the award. Today, does St. Francis believe that it was a responsible bidder as defined in the statute?
I would not have signed the contract.
So I'm going to press you. Is that a yes or no?
I would not have signed the contract.
St. Francis was awarded the contract. There was an intent to award in, I guess, June of 2019, June 3rd. What was St. Francis's reaction to being awarded the contract? Understanding, what was its reaction internally and operationally?
I think there were 2 different perspectives. From the program side and the finance side, there was surprise that they were awarded the contract, and there was concern. From the senior leaders that were there was also a surprise that St. Francis was being awarded the contract, but yet there was excitement that they had been awarded the contract. Belief at the time when the intent to award was made was that the contract was a good contract for St. Francis, including financially from the senior leader perspective.
At what point in time after the intent to award were concerns raised that you just described, I think a moment ago, that we should not move forward with the contract? At what point was that flag raised within St. Francis?
I can't give you an exact date, but I would say based on my conversations, in the relative near term after the intent to award was made.
Perhaps, is it fair to say it was in the June 2019 timeframe?
I think that's the first statement.
Okay. And Mr. Clark, at any point, did anyone at St. Francis tell anyone at the state of Nebraska, we should not move forward with this contract?
To my knowledge, they did not.
Did anyone at St. Francis advise senior leadership that if the contract moved forward, right, that if the contract was signed, that St. Francis would not be able to meet its obligations under the contract?
There was discussions that the contract was not financially sound. To my knowledge, there was no discussion that from a programmatic perspective, they would not be able to deliver, but rather that the contract, as we discussed just a few moments ago, would be a financial loss for the organization. And that was a concern.
With respect to the concerns raised as it relates to the intent to award and then concerns relating to we should not sign the contract, were there discussions about not just the finances, but the impact on Nebraska's children if St. Francis were to be given the contract? There would be a negative outcome on Nebraska's children?
To my knowledge, those discussions did not happen.
So the focus, is it fair to say then the focus with respect to moving from intent to award to contract internally at St. Francis was about cost?
To my knowledge, yes, that's an accurate statement. When I look programmatically, there was and still remains today that St. Francis can take care of children and families in the Eastern Service Area.
To clarify, I think before we sort of move out of this area of questioning, Mr. Clark, I think your testimony was that the senior leadership believed it was a good contract for St. Francis. Can you clarify what you mean by that, or maybe get an expound on that. A good contract in what way?
I think they felt that it was viable, that they could find a way to financially satisfactorily move forward.
Can you explain I'm gonna talk now about a little bit more detail with respect to the RFP proposal. And in particular, we're gonna talk about that caseload ratio issue. So can you explain what is the dyad model?
The dyad model is actually a best practice. It's best suited where providers or services are not available. A dyad team is an all-encompassing two-person team to perform the work partnered with child. Parent visits, transportation, they do all the visits together. It provides a second set of eyes to do the work. It allows the organization to move to a ratio of 25-1 because you have two workers who can focus across the spans of the caseload ratio.
Would the dyad model as proposed in St. Francis's RFP response ever have provided a ratio that was going to meet Nebraska's statutory requirements?
To my knowledge, in the way that the RFP was bid and submitted with the number of personnel in there and the costs associated with it, no.
So just to state that another way, even with the dyad model, St. Francis was not going to get better than 25-1.
St. Francis, at the time they submitted the RFP, believed that the dyad model was acceptable. That the 25-1 ratio, which is a normal course of business for St. Francis, they thought that was acceptable when they submitted their RFP.
And we know from your prior testimony that 25-1 was not acceptable, correct?
Correct. 17-1 is the state statute.
There has been some testimony today, and some information provided to the committee that in the late June 2019 timeframe, there were questions raised by individuals at the state of Nebraska relating to whether St. Francis could meet the statutory caseload requirements. Are you familiar with those communications?
I am. They're dated 24th of June.
Okay, and so in particular, we heard some testimony from Mr. Botello today relating to those communications where I believe the state said to St. Francis, will you meet the statutory requirement? And the response from Mr. Blythe at St. Francis was, we will meet the statutory requirements, provided that our cost proposals increased by $15 million. Is that a fair summary of the response from St. Francis?
Mr. Blythe stated that they would meet the requirements, but in doing so, requested an additional $15 million to meet that, to which the response back was, we cannot change the cost of the contract.
Right. So and I do want to make sure, and if you need to refer to it, it's next to you in that white binder. If you don't have it, I think it's tab 1 in CEO Smith's testimony from January. But the response back from Mr. Blythe is, I think, very, very specific. It states that St. Francis will switch our proposed model to a case management staffing model, which would provide one case manager for 12 to 17 cases. That's the statutory requirement, correct?
You're correct. I'm looking at the email traffic.
Yeah, okay, great. And then Mr. Blythe says, in order to make this change, St. Francis will need to increase our cost proposal by $15 million for the life of the contract. Do you view that statement by Mr. Blythe as a request or a statement that to do the statutory requirements, $15 million will be required?
believe that Mr. Blythe is stating that to change the model, it will cost an additional $15 million. That needs to be added to the contract cost.
And the response from the state, as you noted, was you cannot increase the costs.
Correct. The response was any increase in cost would invalidate the bid. In order to be a valid bid, St. Francis would have to meet the requirement that the cost proposed and accepted in the bid.
That communication from Ms. Walton at DAS was sent to St. Francis. It's dated June 17th, 2019. There was a meeting held on June 26, 2019. Are you familiar with that meeting, Mr. Clark?
If I can take a step back, please.
Sure, please do.
You mentioned that the communication from Ms. Walton was dated June 17th. The one that I have and that I'm tracking is dated June 24th.
Apologies, the original communication
Okay.
setting forth the requirement was June 17th. You're correct. The
Just so-
response back, yes, was
Just
June
make sure we're
24th.
looking at the same.
Yep, sorry about that. Is it St. Francis's view that the conversation between St. Francis and DAS relating to the caseload ratios and the $15 million request led to the June 26, 2019 meeting?
I do not know. My understanding of the June 26th meeting was a refinement of terms and conditions.
Have you seen the agenda from that meeting?
I have not.
Did you hear Mr. Botello's testimony this afternoon relating to that meeting?
Yes, ma'am, I did.
So I'm going to ask you for St. Francis's knowledge of that meeting. First of all, can you state whether Diane Carver attended that meeting?
Yes, ma'am, from St. Francis, there was three people who attended. Tom Blythe, Diane Carver, and the former interim CFO.
So did you speak with Ms. Carver about that meeting in preparation for today?
Yes, ma'am.
What is St. Francis's, and I think it's probably, did you speak with the former CFO in preparation for today?
No, ma'am.
So I'll make the assumption that your knowledge is based on Ms. Carver's recollection, but I will ask more generally, what is St. Francis's recollection of what occurred at that June 26, 2019 meeting?
It was a short meeting, approximately an hour, very quick. Mr. Botello laid out the attendees from DAS and DHHS. The intent was to negotiate the finer points of the contract. Part of that discussion had to do with rewriting the RFP tied to the kinship workers, which was discussed earlier today, and moving them from kinship to case managers. There's about approximately 24 positions that were moved from one piece to the other. A kinship position is not a case manager. A kinship position is a support type person. They were moved to assist in meeting with caseload ratio requirement.
I'm going to drill down a bit more with respect to that meeting and especially what St. Francis's understanding was. Were there statements made by any state attendees, and I won't limit it to DAS or DHHS, any state attendees, that if St. Francis did not alter its caseload ratio, that it would not get the contract?
I have no knowledge of that. If that was issued inside that meeting. I know inside the meeting, the work was done to move workers from one box to the other.
Were there discussions during that meeting between St. Francis and the state about the $15 million request?
I do not know, and that's not something that I discussed with Diane Carver.
the movement, I'll use your words, I think the movement from kinship workers to case managers, does that have a cost increase?
Yes, ma'am.
Was there any attempt during that meeting to detail for the state what that cost increase would be?
I don't know.
Do you know today, just based on St. Francis's experience, what that cost differential is? We're talking about 24 kinship workers now becoming case managers, what that cost increase would be?
I don't.
Coming out of that meeting with the shift from, well, and let me clarify your testimony, Mr. Clark. You said that there was a shift from kinship workers to case managers, and I may have misunderstood you. Did that shift, it was, came out of that meeting, or it happened during that meeting where there was just a decision made during the meeting? We're moving on.
During the meeting.
During the meeting. Who directed that shift?
I don't know who directed it. I know that Ms. Carver went and did the work inside the meeting off to the side to come back with the solution.
So Ms. Carver left the meeting.
She did not leave the meeting. She remained in the room.
Oh, okay. I should have asked, was the meeting in person
Yes, ma'am.
here in Lincoln?
Yes, ma'am.
So Ms. Carver sought to work, so got right to work. Was it as simple as what I think of as a word processing task to simply take, the RFP response and move these kinship workers to a different, literally change the name? Is that what we're talking about?
I do not know the process she went through. What I can tell you is there's a difference between a kinship worker and a case manager. Skill set, cost. When those positions were moved, that then left St. Francis with a shortage of kinship workers, in which when I came back in January of this year, we then sat down to rework the emergency contract. We added more kinship workers back into it.
And that was going to be my next question, is whether kinship workers in St. Francis's view are required team members to fulfill the services to the Eastern Service area.
Without a doubt.
During the June 26, 2019 meeting, was there a discussion about the 65-35?
I don't know.
Do you have an understanding, Mr. Clark, with respect to St. Francis's original bid response on the 65-35 requirement? Do you know what St. Francis's original proposal was with respect to that ratio of direct services versus contracted?
What I know is that St. Francis expected to do the work in-house. St. Francis is accustomed to partnering with providers to assist with work, but the expectation is that preponderance of the work is done within the organization.
I sort of jumped us ahead, but now I'm going to jump us back. During the June 2019 meeting, was the overall staffing plan discussed during that meeting in terms of just, I've seen, the staffing plan, right? Which workers will be where, or was it just talking about that case manager ratio?
To my knowledge, the topic centered around the case ratio load requirement and how does St. Francis meet that.
Did St. Francis believe coming out of that meeting that simply reassigning positions, for example, from kinship workers to case managers, would meet the RFP requirements without adding cost?
I'm pausing because I think the answer is no if you go back and look at Tom Fleck's email to the state of I need to increase the contract by $15 million. And so there was an expectation by moving away from a dyad model that the cost would increase, also knowing that a kinship worker is not the same cost as a case manager.
During the June 2019 meeting, we talked about that movement from kinship workers to case managers, and that Ms. Carver sort of set to work right away, even during the meeting on that. During the course of that meeting, were there discussions about adding to the total number of staff that St. Francis would need in a broader sense?
To my knowledge, no. We never had that conversation.
So with Mr. Vitello this afternoon, I talked about sort of St. Francis's original staffing plan, and then the staffing plan that was ultimately prepared and posted in conjunction with the contract. And I was referencing that I hadn't done the math, but since we have done the math. So the original bid overall to service, this contract had 275 employees. The signed agreement had a total of more than 303 employees. I don't know how you, a half an FTE, so it was 303.5. So that was an increase of 28.5 humans needed to do the work of the signed contract. Assuming my math is correct, were you aware of that staffing increase prior to just today?
I was not.
Okay, so I think I'll ask you the question, is it realistic in your experience at St. Francis that an increase of 28.5 employees would have no cost increase?
That would not be my experience.
Regardless of what titles they held, right?
Correct.
Do you know whether anyone at the state ever asked, and in particular at DHHS, ever asked St. Francis about that increase in just human capital, at 28.5% increase?
I have no knowledge of that.
I may have asked this already, Mr. Clark, and if I have, I apologize. It's late in the day and I'm not re-asking it for effect. I'm just making sure I'm being thorough. At the June 2019 meeting, were there any representations made by anyone from the state that if St. Francis needed more money later, after the contract, that more money would be provided to St. Francis?
Not to my knowledge.
Was there an understanding on the part of St. Francis that the opposite, right? Well, we'll just ask, and because we're providing an essential service, we'll probably get it. Was there that understanding within the organization?
No, I think it goes back to people understanding that the bid, the contract, initially had a loss for St. Francis, and there was concern about that. But former seniors believe that they could figure out a way, whether that be through philanthropic efforts to make up the difference, and they'd find a way to do that.
Mr. Clark, did St. Francis have an understanding from the state, particularly coming out of that June 2019 meeting, that the state was going to great lengths to ensure that St. Francis and the state ultimately reached a contract? Did St. Francis have an understanding of whether there were other options on the table on the part of the state?
St. Francis was aware of the intent to award the contract. They knew of the protest by Promise Ship. I think in June as that was going on, St. Francis was diligently working with the state, DHHS and DAS, to work through the refinement of the contract. To my knowledge, there was never any discussion of there's no alternative option, or we have to go down a certain path.
Do you agree that St. Francis changed its bid, at least with respect to the staffing plan, after the meeting on June 26, 2019?
St. Francis changed its staffing plan.
Do you think that that had a material impact on the original proposal submitted by St. Francis?
I don't know. I think that'd be speculative. I think that knowing that a kinship worker is not a case manager, going back to Mr. Blythe's request, as we've talked about, that would seem logical to me that would follow.
Going to ask this maybe a slightly different way. Do you agree that the change in the staffing plan would have affected, and really positively or negatively, right? But the change in the staffing plan would have affected the quality of services provided by St. Francis?
It would have changed the quality, both to the positive and to the negative.
And I think you just said this, but let me be clear. Would the change in the staffing plan have affected the cost to St. Francis, at least, of providing the services?
I would have expected that it would have.
In your view, is the change from a 25-to-1 caseload ratio to I'll just cap it at 17-to-1 caseload ratio, a minor change?
Is it a minor change? No, it's a change that must be reviewed and based upon the size of the organization or the area that you're serving. Could be significant based on the number of children in that area. It would definitely require the organization to take a step back and relook at it.
Thank you. Mr. Clark, I'm going to talk a little bit about that caseload transition that I think was originally determined to, or I guess intended to occur in January of 2020, but then ultimately was kicked off in October 2019. I'll ask the easy question first. Did St. Francis request that expedited transition?
No, ma'am.
When the state requested it, how was that communicated to St. Francis?
I think from the beginning, St. Francis was expecting transition to begin in January of 2020 with a gradual transition, not all cases at one time. When the transition began in October, St. Francis stated they were not prepared to do that. They didn't have all the personnel in place. At the same standpoint, St. Francis wanted to be a good partner to move forward. Understood that Promise Ship was losing staff quickly and was unable to maintain caseload ratios. With that, St. Francis wasn't ready. They didn't have the infrastructure in place. What I mean by that is IT, transportation, to include some personnel positions were filled as well.
I don't know if you heard Ms. Smith's testimony this morning, but I think if I would summarize it, and I truly am summarizing it, I think it was her testimony that St. Francis was set up for success from the outset of the contract. Do you agree with that summary?
I did hear CEO Smith's testimony discussing the readiness reviews that they were conducted, and they were conducted. From where I sit right now, and the individual I talked to, St. Francis was not prepared to move forward. There was a pledge of support from DHHS tied to mobile crisis response team to help with the earlier speed up of taking cases. That never materialized, even though the expedited process began.
We know that St. Francis, and I think even in your opening testimony today, has had issues with maintaining that required case manager ratio really since the beginning of the contract. What, if anything, did the expedited transition of cases to St. Francis play? What role did that play in those ongoing challenges?
I think initially it had an impact ability to maintain proper caseload ratios. I guess I'll go back to my open comments as well. Since St. Francis took over the contract, the world has completely changed. The COVID-19 pandemic has had a significant impact, not just in the state of Nebraska, but across the country and across the world. Employment conditions in 2020 and 2021 are not the same as they were in 2019. So the expedited transition, yes, it impacted that. To say that it has always been tied to that, I think would be a false analogy. I think there's more factors in play now than anybody ever anticipated.
Mr. Clark, does St. Francis believe that anyone at the state, well, let me start over. Does St. Francis believe that anyone in DHHS knew that St. Francis had underbid the contract?
To my knowledge, no.
Does St. Francis have any information indicating that anyone at DHHS suspected, was concerned about the underbidding of the contract?
To my knowledge, no.
Those are the questions that I have for you. I think I'll turn it over to Chairman Arch for some questions and, of course, the committee.
Thank you, and thank you for your responses. I want to go back to the dyad model.
Sure.
Was that previously in place when the RFP bid was submitted? In other words, did St. Francis Ministries have experience with that dyad model elsewhere?
Yes, sir.
And
Extensively
where?
in the state of Kansas.
In Kansas. Is that currently your model in Kansas that you're using?
Yes, sir.
Do I understand the dyad model correctly, that you would have I don't know what, a case manager, and then not a case manager, but someone at lesser training to do a lot of the work that the case manager does? In other words, they would divide. Is it like, I use the analogy from medicine, where you would have a physician extender, you would have a physician assistant along with an MD, but they could work together as a team. Is that the philosophy of the dyad model?
Yes, sir. Actually, you're very close. So that position is called a family support worker that partners with the case manager.
You say family support worker?
Correct.
Okay.
And they partner to oversee all aspects of taking care of the family and the children. But much like in your example with the physician, ultimately the MD, the doctor, has a decision-making authority. Same thing with the case manager. The family support worker works all the administrative pieces to help support that. Obviously, they have experience working with children and families as well.
This is probably a difficult question. Well, they're all difficult questions, but if that dyad model, if were it not for the state statute on 17 max caseloads, if that dyad model had been acceptable to the state of Nebraska, do you believe that the bid in St. Francis Ministries proposed, the bid would have been a reasonable bid given that model? Did you still have problems within your bid independent of the dyad or no dyad model?
I would have a problem, sir, with any bid in which we were losing money. As a nonprofit, you can't sign a contract like that.
So even if the dyad model had been accepted, you still would have been losing money.
The way that the RFP was written under the dyad model, you're correct. St. Francis was going to lose money.
Okay. And I am assuming, and maybe I shouldn't assume, is the reason that the dyad model was submitted, or I should say, the reason that St. Francis thought that the dyad model would be acceptable to the state of Nebraska was because they did not have knowledge of the statute requiring a 17 max caseload?
I believe that's part of it. St. Francis operates from a dyad model. As I mentioned, it is a best practice, especially when other providers are not available or used, which is the normal practice for St. Francis. So I think understanding how St. Francis does work through a dyad model and not knowing state statute, St. Francis moved their RFP forward based upon the dyad model.
Okay. Back to the June 26 meeting in 2019, when that meeting occurred and it was agreed that these kinship workers would be reclassified, moved to a different position, is it your understanding, or was it St. Francis Ministries' understanding, that those kinship workers would have qualified as case managers? In other words, education, experience, whatever the qualifications are, they could simply move from kinship to case manager?
They would have not have qualified as a case manager. They would have had to hire differently. So when St. Francis took over the contract, you say they're hiring all these different personnel.
So this is an FTE. This isn't necessarily a kinship. It was a moving.
Correct.
It was a moving of FTEs, maybe at a different rate or a different cost per FTE, but they simply moved positions. They didn't really move kinship workers over and call them case managers. Am I correct?
Correct.
Which then caused you problems because now those kinship workers were needed, but those FTEs are gone.
They were gone initially. When the new contract was written and signed, there were positions put back in there.
Right, until that new staffing plan was presented at no additional cost.
Correct.
Okay. Totally different subject. I want to give you an opportunity to talk. Recently the license of the child placing agency has been granted, but on probationary license with restrictions. What's your perspective on that? And where are you now as an organization with eliminating the deficiencies and the issues there?
We've had numerous discussions with DHHS on this topic over the past few weeks, as you can imagine. St. Francis employees have been partnering with DHHS employees going through records. A couple of comments from my perspective is the first year of the contract, when I went back and looked at it, the previous St. Francis leadership didn't focus on that area. Since we have transitioned the leadership to the current St. Francis, we have brought new leadership into the Eastern Service area. We've identified the gap really on the kinship side, which impacts this. And so we have individuals who are diligently working that right now. We've been hiring very quickly. So for example, there's now 25 authorized positions tied to that. 17 are hired. We have 3 more scheduled to start next week. But it's been a challenge hiring them. So the first part of the contract, St. Francis has to own. They didn't focus on that properly. As I mentioned, staffing was significant to them. When you move the positions from one box to the other, you take away the ability to work on that topic, which eventually came back. We see the results there right now. I also think there's some complexity inside the state when you look at CPAs as a whole. So CPA being a provider receives a license from DHHS,
I'm sorry, CPA?
CPA, Child Placing Agency.
Thank you.
And so DHHS retains the right or the authority to license all CPAs so they can place children. That falls within the 65 to 35 rule. And so all the subcontractors that we utilize, or providers, as we refer to them as, are licensed and have a valid license with DHHS type. And so when I look at this, number one is we are held accountable, St. Francis lead agency, for those providers and their records. Rightfully so, we have a responsibility to make sure they have the right records in place. The challenge is St. Francis doesn't license them, DHHS does. So when DHHS licenses those CPAs or providers, St. Francis' ability to influence that becomes strained. The other thing is there's not really a central data repository in the state. InFocus is not a system that's designed to do that. And so we're in the process of right now of actually building a SharePoint. So we can go out to all these 17 different providers that we use for their CPA information to put it into a database. As St. Francis is held responsible by DHHS for having that information on hand at all times. And so we're working through that. We've had some productive meetings. We just did another one yesterday. There's a plan in place to provide data and updates every Friday going forward. As I mentioned, the hiring piece of being able to hire people to help solve this challenge has been significant. As I sit here today, knowing what we know and what I call the partnership of trying to solve this, I'm confident we're going to get there in time.
Thank you. Other questions from the committee? Senator Merman.
Thank you, and thank you for testifying. I got to apologize, I missed quite a bit of the meeting today. I had a hearing in a different committee, but I'm a little disappointed that we've talked so much about financial things and very little about the quality of care that the foster kids receive. I know there's a difference, as we've talked about, between Kansas and Nebraska, the requirements, and also apparently between what St. Francis provides in the rest of the state compared to the Eastern Service Area, being the lead agency there. What's your opinion on the differences between Kansas and Nebraska or Eastern Service Area and the rest of the state? Is the quality just as good with those differences in requirements?
The requirement of St. Francis in the western half of the state is completely different than the Eastern Service Area. In the western part of the state, we really focus on foster care. We don't do case management out there. And so it's a completely different work. St. Francis Ministries as a whole is not the lead agency in western Nebraska. Rather, we have an arm of St. Francis that serves as a provider or a CPA that does that type of work and answers to DHHS. The complexity of the ESA is completely different. Metropolitan areas are much more challenging to work through. There's a lot more children, as I mentioned earlier. 45% of all children in care in the state of Nebraska fall within the Eastern Service Area. Right now, I think when you look at comparing Kansas to Nebraska, they're completely different states, the way that they operate, and really even the way that in Kansas it's called DCF. The way DCF looks at things is different than the way DHHS looks at them in the state. So Senator, I don't think it's a fair comparison from one state to the other. Much like I don't think it's a fair comparison from western Nebraska to eastern Nebraska, just based upon the work that's being done.
So caseload, there's different criteria that in, for instance, Kansas or the balance of Nebraska that kind of compensates for the differences in caseload requirements.
So Kansas, as I mentioned, we're able to use the dyad model. That's an acceptable practice in that state. And it works well. As far as Western Nebraska, the case management piece that we're talking about, that's actually overseen by DHHS. That is not an aspect that St. Francis even works to provide in Western Nebraska. We only work that aspect of the care of children in Eastern Nebraska.
So if I may, so by Western Nebraska, you mean everywhere except the Eastern Service Area?
There's actually 2 service areas of the 5 that are metropolitan in nature. One is the southeast, which is tied to Lincoln. Then you have the eastern service area, which is tied to Omaha. The 3 other ones are the more rural areas of Nebraska. The area that we operate in Western Nebraska is really focused around Grand Island and further west.
So that's not the southeast, but it's further west than the southeast.
Correct.
Thank you.
Other questions? Senator Clemens?
Thank you, Mr. Chairman. Thank you, Mr. Clark. Regarding your difficulty with staffing and hiring enough case managers, does St. Francis Ministries pay comparable wages to what direct DHHS service providers receive?
Yes, sir, they do.
So
Actually, I
that,
would say that they pay better than what DHHS pays.
so you believe you are offering competitive wages, but so you would say it's the lack of applicants that's the problem?
There's definitely a lack of workforce. I'm gonna say across the country, because this experience in other states we work in is really no different. On the social welfare side, other organizations, think of for-profit entities, are starting offering much higher wages that social organizations such as ourselves or even the state have a hard time competing with. So a starting wage of $20 an hour, for example, in Costco is not something that organizations, whether it be St. Francis or the state, is competing with right now. And so what we're seeing is employees opting to leave a vocation that they've chosen because financially it's more viable for them and their family to go work someplace else.
Thank you.
Senator McKinney?
Thank you. I guess my question, you said that, it's tough to hire people because you're competing with Costco workers. Do you think the issue isn't that it's the pay? Is it more so how you value case managers? What I mean by that is not only the pay, but also benefit-wise and things like that. Do you think you could do a better job at, 1, paying more, 2, providing more benefits, and 3, making the job of a case manager less stressful and more professionalized?
Senator, I think there's a lot to unpack there if I can. I think there's multiple questions here. Can we do a better job? I think all organizations that want to do excellent work can always do a better job. Always looking to get better. But I'd like to give you some examples of things that we are doing from the pay side to be competitive, as well as what I would call non-pay areas. We're currently doing what I call time of service bonuses. We've been working with the organization. We have a mentoring program for case managers, and so our more senior case managers, if they sign, help younger case managers reduce some of that stress, and they receive a bonus. We have retention and performance bonuses that we have in place right now. We have referral bonuses. So if you were to have somebody come and join the organization, you brought them, you receive a bonus for that. If you're a fully trained case manager when you come to us, there's a bonus just for being fully trained. As you probably are aware, when you hire a new case manager, they have to go through about a 9-week training period before they can begin. If somebody's bilingual, there's extra pay for that. Some of the things that we do that we think are competitive, not necessarily on the pay side, but just overall, we allow our employees to do telework, which we found that to be a great benefit to include our case managers. We provide flexible scheduling, realizing that case managers do not work at 8 to 5 jobs, at times that they have to meet with families, family members at night. We have more of a casual dress policy to meet the needs of what they need to do. So if they're out in the field, they don't necessarily have to wear a coat and tie. And we allow them to bring their infants to work. They're a new parent, and so they have the opportunity, which takes away some of the child care needs. We have internal training. We provide fleet cars so they have to use their own vehicle. We have a very, I would say, competitive 401k match. We have paid holidays, paid life insurance, accidental death and dismemberment. We pay for long-term disability. Obviously, they get the normal earned time off, sick time, those things. And we have an employee assistance program, so if somebody feels that they're have a stress in their life and they need to be able to turn to somebody or a counselor, and we have that option available to them. Can we get better? Yes. In fact, right now we have work groups working within our own HR department to see how we can even add more to this. Part of that includes bringing frontline workers into those sessions to get their view of what's working and what's not. So can we get better? I think we can always get better.
Okay, because I mean, I know within probably the last couple of months, I did see some workers from St. Francis protesting. And we also met with some judges, and one thing that stuck out to me, one of many things, was that the judges saying case managers were coming to court unprepared and just being thrown to the wolves. Why is that?
Well, that has to do with the case manager turnover. There's been a high rate of case manager turnover. So, as I mentioned earlier, case manager turnover is 7 times the average in any profession. Part is because of the stress that you mentioned, Senator. It is a very demanding profession. You put yourself in challenging positions at times and places, in stress, or when you can see the impact to a family. And so I think we talk about being unprepared. Part of it is the turnover. The other piece is St. Francis had to look internally at itself and how the process that we were utilizing to be prepared to go to court. About 4 months ago, I was part of the process. I reviewed that. It had my attention. We rebuilt the process. As part of that, we hired a brand new corporate general counsel, which we did not have, which has been helping to oversee that work to ensure that we have the right people at the right place at the time with the right information. When I go back and look, for example, in the month of September and the results in that, what I see is basically 99% of the time we're meeting the requirement right now. Are we perfect today? No, sir, we're not. But where we are today compared to where we were 4 months ago is completely different.
Also, I don't have the facts to back this up completely, but I've heard stories of St. Francis I've heard stories of St. Francis pretty much inaccurately tracking visits, home visits and things like that. Do you think that's without merit, or do you think it's possible that some staff within St. Francis may have falsified visit documents?
I think if we know that an employee falsified a visit, we took corrective action. That's not acceptable. Visiting a child is what's expected, is what you need to do to ensure their safety and there's no maltreatment. And so if we have a case manager or an employee who's putting false information inside InFocus, they did a visit and they didn't, we would not allow that to happen.
How would you grade from the time St. Francis has taken the contract to now? How would you grade your performance on a scale, on a A, B, C, D, F scale?
I think when you look at the data that's out, that I would say is impartial data, going to that foundation report that I mentioned, Nebraska has increased. If you look at data that comes out from the Children's Bureau, the Department of Health and Human Services at the federal level, and how Nebraska has come off of a performance improvement plan the past 2 years, and our meeting requirements, there's been no financial losses. St. Francis has had a significant piece of that improvement in all aspects, on both of those. Because 45% of the children fall within the ESA. Am I satisfied with where we're at? Absolutely not. We need to hire more employees. We need to get more case managers. We need to reduce caseload ratios. Am I proud of the employees that are inside St. Francis and who are working 60 to 80 hours a week? Absolutely. Am I proud of the corporate team members who are up here from different parts of the country, basically living here to help? I am. I'm proud of the St. Francis team members from Western Nebraska who come over here to help. I am. Sure, we can get better, and we're striving. I think if you look at the data over the past 3 months, you would see that there's been improvement in all areas. And we will continue to press that.
Okay, and my last question, do you, because I know CEO Smith mentioned earlier that coming into the contract, the department set you guys up for success. Do you think you guys were set up for success in the beginning, or do you think you guys weren't, and you weren't because of the proposal you put in place, which got accepted?
When I look at the transition, of the expedited transition, St. Francis was not prepared for that. It happened too early. Didn't have all the people in place to start beginning to do that. Did not have the right infrastructure in place, which was really one of the reasons that I was hired to help build that.
Are you aware of anybody within St. Francis making the department aware that they weren't prepared for the transition, or did it just happen?
Senator, I don't know. Those people who are responsible for that are no longer part of St. Francis. The team members that are still with St. Francis, who don't work in the Eastern Service area or part of the corporate structure, as I've talked to them, have all relayed that we weren't prepared. Wrong staffing structure in place at the time. The wrong support structure. Just wasn't ready to go yet.
All right, thank you.
Yes, sir.
Senator Hansen.
Thank you, Chairman Arch. Thank you, Mr. Clark. Just to follow up on Senator McKinney's question, how about the potential of data being misrepresented? Has St. Francis ever had somebody or caught an employee putting improper or falsified data into a database like InFocus?
Have they ever taught them how to do that? Was that the question?
No, have you ever caught? Has an employee ever been caught for doing that and reprimanded?
Yes.
You did? You have? Yes?
Yes, sir.
Can you give us frequency of how many times that has happened to your knowledge?
To my knowledge, it's been infrequent, but it has happened. And when those situations have transpired, obviously it works within the HR arena that the appropriate action has been taken.
And do you have any sort of internal audit procedures to catch or track that? In other words, how did you catch the people that you did catch?
We do have internal audits. We have leaders, supervisors, and directors who are auditing a certain percent of the information inside InFocus on a monthly basis. One, to making sure that we are complying with the requirements. Two, to see if we are having any challenges that you're discussing. We also have a completely separate team that focuses on data. And that team also goes in our audits as well. And so we have I'll say disinterested, in other words, we're not in their normal chain, looking at the data from that lens as well.
All right. Thank you.
Other questions? Senator Kavanaugh.
Thank you. Thank you, Mr. Clark, for being here today. I have a lot of questions. I'm going to try and synthesize them to be not too many. You mentioned that the transition happened too early and you didn't have the right people in the right place. Then previously you said something about a mobile response unit. Was I hearing you correctly? Did the Department of Health, our Department of Health and Human Services, promise you a mobile response unit to move up the date of the transition?
Correct. From my internal discussions with team members, to help move the transition to a quicker period of time, the HHS said they would support with what they called mobile crisis response teams.
Who did they tell that to?
The leaders of St. Francis at the time.
And that would be Father Bobby and Mr. Blythe?
I would say that's probably more on the program side, ma'am, than the CEO and COO. So if you think of program people who are actually doing the work, that's what I was at.
Okay, and that never came to fruition?
Correct.
Are you aware of any further conversations between St. Francis Ministries
No, ma'am, I'm not.
about it? Okay. Going back to the beginning of your testimony today, you said that you came to St. Francis Ministries from the merging of St. John's Military School,
Correct.
and you said that they merged together.
Correct.
So can you explain that to me a little bit more? Were they, did they have a same board, or how did they merge together?
They were not aligned at all. They are both tied or faith-based from the Episcopal faith perspective. St. John's had made a decision to close after 131 years of operations. When that announcement was made, Bobby Smith approached the school about the potential of exploring a merger between the two. St. Francis Ministries, the corporate office, was in Salina, Kansas, which is the exact same location as St. John's Military School. And there's discussions of the potential of St. Francis Ministries utilizing that campus to further services for children and families.
Did
The
they
boards
use-
are, excuse me, the boards are completely different, not aligned at all.
Did they utilize the campus then?
Currently, the corporate office of St. Francis Ministries has moved on to the campus. We have partnered with other entities inside the city to
And-
utilize that campus.
And were any assets that were with St. John's turned over to St. Francis, or how did that merge look?
All of the assets were turned over to St. Francis.
So another question about the board. Does the St. Francis Ministries board weigh in on large contracts such as the one with the state of Nebraska?
I'm going to answer from my perspective as the current president and CEO. Whenever there's a contract dealing with a state entity, I take it to the finance committee for official review, which includes showing them the budget. We have discussions with that. Once they're satisfied, then we take it to the full board for ratification and approval. I cannot speak if that process was in place prior to me assuming my position.
Prior to you being on leadership?
Prior to me taking over as the president and CEO.
So when you joined in November of 2019 up until October of 2020, you're not aware of that being the process?
I was not part of the board meeting structure.
But you have access to previous board meeting minutes?
I could go back and look at them. That's true, I could.
Okay. Okay. I'll just ask one more question, because I have too many. So the hearing that we had, the public input hearing that we had, I don't know if you saw it or if it was reported back to you, but we had a foster parent come and testify, and she informed the committees that herself and several other foster parents had been told by staff members at at St. Francis Ministries that they would be removed from, their children would be removed from their home and they would no longer be foster parents if they came and testified. Has anything been done to look into that and to find answers as to whether or not that happened and why that happened?
I'm aware of that. That came out of that hearing. And so on the 8th of September, shortly thereafterwards, I sent the Executive Director of Compliance and Executive Director of Support Operations, which safety and security falls underneath his purview, to meet with that specific caregiver and also providers in the Omaha area. They discussed any potential allegations regarding threats. The caregiver at the time stated to that team I sent up there that the foster parents stated that they could not be involved in the hearing of which you referred to. During that hearing, during that meeting, the caregiver did not state that they were threatened. They just said they were told by the case manager that they couldn't participate. On September 10th, 2 days later, as we continued the investigation, we spoke with the case manager directly about the allegation that was made. In that discussion, the case manager stated that the caregiver really wanted to speak to a judge about the case itself. The case manager stated that she advised the caregiver that she needed to speak with a GAL, guardian ad litem, initially, and the forum on the 31st was not the place to do that. The case manager says in no way did she threaten the provider, excuse me,
Foster parent.
the caregiver, thank you. And so what we found that was inconclusive. We could not, between talking to the caregiver and the case manager, we found no threat. We did do some professional development on how to articulate oneself.
So the foster parent who testified said that she was there on behalf of other foster parents who were told the same thing and that they didn't have the same caseworker. Was that looked into?
Can you state that again?
There were multiple caseworkers
Correct.
telling multiple foster parents not to come testify in front of these committees. And only one came to represent them all.
When we met with the caregiver we're referencing, that question was asked. And we asked if the caregiver was willing to share other names that we could contact so we could explore that. That was not provided. With that, if there are other caregivers who would like to talk, I'm more than willing to do that.
So she stated that very publicly, and we asked questions about it, and now you've had a conversation with her and she did not provide those names. I assume that she would have told those people, and I could have be assuming incorrectly, that you asked for those names and that they should talk to you if they want to. It sounds like this is maybe another opportunity for an increase in due diligence into the processes. Because if it's more than one case manager that's telling foster parents these things, that they can't talk to us, their state senators, then that's not one case manager doing it. That is management telling them.
I don't know if the caregiver in this case went back to those other caregivers and said, I just met with them. They'd like to meet with you. I don't think anybody knows that except for the caregiver herself.
Right.
I think we are making a concerted effort to talk to the families we work with. If they have complaints, and we would love to sit down and hear them to try to get to the right answer, to make sure we're all working together. Since I've taken over, we've created a compliance department. So the executive director comes up here to do that, have those type of sit-down sessions. I'll go back to what the good senator over here, we can always get better. I do feel like we are making strides to move forward and be transparent with families. And if we hear of a problem, we address it very quickly.
I bring it up because for me to hear from a constituent, a person who lives in our state, who feels fear to come and talk to their state senators, that to me, that's a significant concern, a very significant concern. And the fact that they say that they are there representing additional people, I feel personally warrants the utmost scrutiny. So I will just leave it at that.
Thank you. Are there any other questions? Senator Merman.
Thank you. I want to preface my question with, and I'll admit this is a little bit anecdotal, but I talked to a family that has more than one foster child and adopted more than one foster. They're a great family. I don't want to say too much because I don't want to give away who they are. But one of the, I think, foster and adoptions was through St. Francis. And this has been quite a few years ago, maybe as many as 10, I'm not sure. But with St. Francis, they said they had a really good experience. They always talked to the same person when they called in, got the same person, got a hold of them real easy. And with DHHS, first of all, they could never get through. And if they got through, it was a different person every time. So apparently St. Francis did a great job with them. But my question is, with the financial difficulties that St. Francis has had, is there a temptation to maybe provide a better service for who you serve in Kansas or in that immediate area more than in Nebraska?
Absolutely not. The contracts are completely different. They're tracked financially different. We have to give accountability to the funds that are spent by state differently. To include showing how we utilize, in this case, the funds from the state of Nebraska to support the work at the ESA. And those reports are turned in monthly.
Okay, thank you.
Other questions? Senator McKinney?
Thank you. Do you think you guys do a better job not doing case management in the western part of the state?
I think we do great work in western Nebraska. I also think that in the eastern service area, we do tremendous work as well. We can get better. I need to hire more people. We're dedicated to that. The work that we're doing, when you go back and look at, once again, the statistics that come out of the Children's Bureau of Health and Human Services, and you look at such things as maltreatment, we're doing exceptionally well. Kids are remaining safe. Our challenge has remained the case ratio, which we want to bring down. But the team that's in Omaha does incredible work.
Do you think after your probationary period that you guys will not be sanctioning anymore, or will you show that you've improved?
The licensing piece is not really tethered to the case management side. But if you're asking just about a license, I think once we've got the employees in place, which we're just about there, and then there's a better understanding now, I think, between DHHS and St. Francis of the requirement. When I look at what we're being asked to do in the former provider, it's a bit different. The standard's different. Am I confident that once we solve the challenge, we can move forward? I am.
All right, thank you.
Other questions? Senator Day?
Thank you, Chairman Arch, and thank you for being here, Mr. Clark. So I think we established that St. Francis was operating in the state of Nebraska before this contract was bid. Is that correct?
Yes, ma'am.
In Grand Island. But then it was said that when the contract was bid, that St. Francis was not aware of what state statute requires for caseload ratios.
Correct.
So my question is, how are you operating in a state and not aware of what the state requires in terms of caseload ratios?
It's a different type of work.
Okay,
In western Nebraska, we focus on foster care and foster care homes, not doing case management. The statute is tied to case management, which we do in the eastern side. So we do different work in different parts of the state.
okay,
And so when St. Francis came up here, and they were using their experience on the western side of understanding Nebraska statute, which did not really apply because it's a different type of work.
okay. So there was nothing in the work that you were doing in Grand Island that would require you to understand caseload ratios in the
Correct.
state? Okay, thank you.
Other questions? Seeing none, we also want to give you a chance, if you have any closing remarks you want to make sure we understand.
I appreciate the opportunity to be here, as I stated at the beginning. We are striving very diligently to be transparent and open. When we have a gap or a seam, we own it right now. We'll continue to do that. We've remained committed in what I consider a very unprecedented time and environment. Kids in the Eastern Service area, when you look at maltreatment, you look at safety, are doing exceptionally well. If you look at what Nebraska has done from a federal perspective and how they've improved overall, St. Francis has had a significant impact on that because of the performance. The past 90 days, we have improved our performance significantly in all aspects, whether it be in the courtroom, whether that be in caseload ratio, whether that's be getting better with CFSR data at the national level. We're committed to that. We have great team members in Omaha. Our regional vice president is sitting right behind me, works tirelessly with her team to care for kids, because that's what it's about, is caring for kids. So I appreciate the time to be here. If there are other questions that the committee has that you want to get to the St. Francis team, we're more than happy to entertain those, to be as transparent as possible.
Thank you. And with that, we will close the hearing for the day on LR 29. Thank you all for attending.
Perfect.